Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. She points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. So kids, remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dreams. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all.
Heyo, folks! Welcome to Slightly Buzzed Show. It's me, and it's Mo.
Yes, and
I'm-
Jingles and Thor.
yeah, Mr. Jingles over here, who has done his best to destroy the left sleeve of my very nice yellow jacket from Temu. And
100% polyester is no match.
100% polyester. I don't,
Yeah,
with
I'm surrounded by
questionable
cats
stitching
today
and yeah.
because
So I-
Mr. Mo's painting and he didn't want cat fur. I was like, textured?
Yeah, I mean, when we laid concrete in the barn, and we thought we sealed off every entrance. Went in a couple of days later to check. Yeah, now it should have dried up, so we can walk on it. And
Oh,
what do
no.
we see? Cat
Jingle
paw prints.
prints.
Jingle
everywhere.
prints. I was like, all right.
You just can't have nice things with pets or kiddos or me. I attempt to keep things nice and
We are live. We are live. Yeah.
yes.
A bit tired from yesterday, but we are live. And for you who wonders, I don't care if you wonder or not. Yes, the wheel of regrets is at play today.
Yeah, it's so interesting because every time I hang out with you, I get into a case that I want to follow, but I haven't had time to. And I know Laura Owens is coming up, so I've been wanting to get kind of into the backstory, but I also time.
Yeah. Time is not on our side.
Well, I
No,
mean,
it
to be
isn't.
fair, I do waste a lot of time, so it's not like I couldn't improve, but there's also like reality that I functionally don't do great with editing. So
Oh, there. Let's shuffle those a bit. Yeah. Dun, dun, dun. So now everything is shuffled around from last week. So yeah, first of all, thank you to Forlorn Tim, who bought me a cup of coffee yesterday. I didn't see it until after the stream, so if you're here, thank you so much. It's much appreciated. I will actually count it into today's Wheel of Regrets. And here's the tale of the take of the tale. I don't have, it's sports talk. Individual supers, gifted memberships, PayPal, give me coffee of $50. You say my poison. Combined $50 gets you a spin on the wheel. That is the tale of the take. And there are currently 16 or 17 slots. And if we empty it all, I'm probably going to fall off my chair and
I was
have
about to say.
and have a burning asshole in the morning. I mean, because of the hot sauce and everything.
Well,
Yeah.
there you go. Things that may or may not be on Nick's, members only streams later on.
Oh. But since it is.
You are so proud of that pickled jar. Now, my mom would be too.
Yeah. Oh, I'm so proud of this. My little jar of pickled everything.
If it wasn't for shipping, I'd have you send me a couple for my mom. I'd be her favorite kid for like 5 minutes.
Yeah. And as I eat from it, I'll just replenish with something. I wonder what this will taste like. And if it's pickled. Yeah. So, Laura Owens, the tonsil twin woman, the serial pregnancy scammer, who finally found an attorney that is as idiot as she is.
Yeah, I'm actually insanely shocked that she found a lawyer of any caliber to cover this case.
Yeah. And I mean, now in the criminal case, the one we saw before is apparently now replaced with a new one that she hired, which is interesting since she claims she doesn't have any money. So that will be interesting.
I thought she was bankrupt. I thought she was poor or indigent or indignant, as Sarah Boone would say.
Yeah. And she had up until, I think it was February 24th for the plea deal they offered. And apparently she didn't take it. And then her lawyer, off I fuck. And all of a sudden she has a new lawyer.
I almost foresee her being like a Sarah Boone in that she'll get lawyers, but she will want them to do things in a way that is not.
She might be reassigned. I don't know. But I mean, it's an actual law group. She got a new attorney from. I forgot what name it was of this new. But I mean, the facts doesn't change. She wants to lie to the court, and she kind of tells her attorney, and which makes the attorney's job impossible, and they have to. So we are going towards a Sarah Boone situation here.
Well, and that's what I'm wondering, if she's going to eventually have to go pro se. And has a lawyer been, or not a lawyer, a judge been assigned in the case?
Yeah.
Is he one that you think will deal with shenanigans, or will he nip it in the bud?
I can't tell, because they are moving towards the complex case hearing, but they only have this notice of appearance stuff at the moment, where they just show up, they talk for a few minutes, and then get a new time slot.
Oh, okay.
Well, she had 7 or 8 in her case against Clayton Eckert, or 5 or 6, I don't remember. And she first then, in the criminal case, she hired one who then fucked off.
Yeah, that's kind
Then
of where
she
I
got
had left it,
and
I
then she
thought.
got an appointed one who now has left. So now she's on attorney number 3, and they're not even at the at an actual hearing yet.
Well, no, and I would think that this would already start continuance or discovery delay problems with, each subsequent lawyer having to get up to speed on the discovery in the case and get a good command of it.
Mm.
In addition to working with Laura Owens, because I've seen the body cam and holy crap, I need a taser.
Yeah, I would have her attorney have a taser.
Well, that's what I mean.
And a chastity belt on both.
Well, I'm a chick.
Yeah.
I mean, just give her a chick lawyer. Give her Kathy Nestor. I can guarantee.
Yeah.
I can almost guarantee nothing's gonna come out of that. I hope. It's 2026 though. I don't want to, say anything too loud.
No, you don't know what people identify as. By the way, did you hear about the transgender killer? How the killing?
Which one?
No, they slash them.
I was like, wait a minute, which one? Yes, you're gonna get hate mail. Send all hate mail to Congress.
Yeah, Congress.
Care of Washington, D.C.
What in the actual fuck? I thought I was seeing spots. It was my dirty glasses.
I know. A white cat's named Thor and Nick's cat's named Mr. Jingles.
Yes. And Mr. Jingles got his name from I could put a necklace on him with a bell on it. Hence Mr. Jingles. Because I could hear him showing up and leaving. And so did his prey. So he learned how to get rid of it. And the next 3 ones. Now, his brother Buster got his name because that's what he did to my arm when I attempted to put a necklace on him with a bell on it. Yeah.
Yeah, it happens. Now, so this is a bar complaint that they have now given him a chance, or he's going to get a chance and opportunity to respond back to it.
Yeah.
And then when will his hearing actually be, or is that still a procedural kind of back and forth?
That could be a while, sadly. That could be a while.
Well, nothing in law moves incredibly quick. So I will say that the Laura Owens has it has moved relatively quickly.
Yeah.
And no, Thor can hear, he just doesn't listen.
And what's interesting here is that this was filed February 25th. So they have waited a while to file this, probably to gather more, because Mr. Gingras can't stop getting himself out of trouble. He can't. He talks more than Corey Richards. I mean,
yeah, because like I said, I've been sort of trying to keep up with it, not as much as you have. And I'm not hanging out or on Twitter, but every time I see him, he's always responding to someone. He can't just keep quiet, which I would think, if a lawyer's advice is to shut the hell up, that the lawyer himself would be able to exercise that whole like shut your pie hole kind of thing.
Yeah, but lawyers generally are a bit tiniest bit narcissistic. Yeah, we tell our clients that, but we don't have to because we know how to do it. And that is why Mr. Gingras wrote blog posts about the bar guy. The guy at his case at the state bar. and not nice ones. And
Oh, I mean, that seems like a bold strategy. I
yeah,
mean, nothing like making fun of someone in power. Uh, see how that
mm,
works out.
I depend on these guys for my living. Let's tell them to fuck off. Generally, not a good idea. Generally, it's like
Y
telling your mother bad words while your father is near. You're going to get slapped, and you're going
or
to
if
deserve it.
yeah, pretty much, pretty much. We didn't grow up with gentle parenting, we had no gentle parents.
Mm. Yeah, he failed shut up class, and his act right was never fully installed.
Y
Yeah.
yeah, I mean, at some point, you have to look at this case and realize not only are you representing
Mm.
someone who will never be a reliable client, who will always be a liability, will
Yeah.
never listen to
Mm.
advice. I mean,
Yeah.
at some point, what is he getting out of this other than in trouble?
Your guess is as good as mine. But with, I mean, Laura Owens is Laura Owens. She she's unable to change. But for the last couple of years with Mr. Gingras, now she gets affirmation from him. And I believe with a better attorney who could talk Laura down, if even that is possible, she would not face these charges because he put her on the stand at that mini trial knowing she would lie. He
Y
had her sign affidavits he
y
knew were
yeah.
untrue.
Well, and that's where, as a lawyer, I would think you bear the responsibility. I mean, that's why Sarah's lawyers
Yeah.
continued to withdraw. Like,
Mm,
as an officer of the court, we
mm,
can't be a party to this.
yeah. Yeah. Well,
And it just doesn't seem like, again, you would want to give your client the smartest advice.
mm,
He's not attaching himself. I mean, if he's trying to use this to gain popularity or hell, I don't infamy.
yeah.
Like, if you're gonna be infamous, be good at it, you know? Don't be a j I dislike more than anything doing a terrible job at something, so if you're gonna go full villain arc,
Mm,
don't do 10% of a half-assed job.
mm. Medieval Martin questioning as Gingras is being charged with the bar. Shouldn't Rob's TRO be quashed due to his questionable behavior and charges? Uh, he's not the. It's just charges. You can't use the writings by itself. They have to be confirmed by the state bar as true with consequences. Then they might be used against the TRO against Rob.
I do wonder if he does have a propensity and it is shown at this, what all he's linked to is going to be affected. I mean, how many cases other than Laura Owens is he involved in that his questionable judgment is going to come up and possibly affect more people's lives?
Mm,
Because not only is Laura Owens
mm,
victimizing, but he's been essential in facilitating her
mm.
victimization.
Yeah. Yeah, what will happen if the state bar decides to sanction him? He has to tell every client he has that he has been sanctioned. If he is and that is regardless if he's sanctioned money wise, if he gets disciplined by you can't practice law for 6 months. He has to tell every one of his clients and facilitate the transfer to other attorneys, all of his clients. And if they remove his bar card completely, he has to tell everyone, and then they can eventually file for. Yeah, you knew this was about to show up, and you still took me as a client, wasting my time. Then he can be on the defense for attorney's fees for his clients, or
Now,
for the change of attorneys.
would it affect any of I know Laura is appealing the ruling. So would him being sanctioned or any of those corrective measures against him affect any of the rulings that have come out
Yes.
that he's been involved in?
Not
And what would that look like?
not the ones that has already been ruled on, but if there
Okay.
are motions that is still in waiting, then he has to redraw those or find somebody who is willing to put their name to it, which I sincerely doubt will happen.
Yeah.
Yeah.
He doesn't seem like I've seen bits and pieces of the hearings. I need to go and cover those completely, but he doesn't seem good. I mean, I'm not a lawyer, but he kind of reminds me of oh gosh, dramas, the first part. He's a whole lot Shatnery.
Yeah. And folks, every month YouTube allows me to gift 10 free memberships. I gifted 5 but a few days ago. Now I'm gifting 5 more. And it went to Rosalind Duke, Advent Turin, Gary Atrix, Dan Extreme, and Forever Caligal. So, congratulations. You now have access to all my members only content, and you get your own emojis here on YouTube's. Yay! And if anybody else wants to join the Viking crew, it's $3 a month. $3 a month. And if you do that while on this stream, it will be counted towards the Wheel of Regrets. All right. Let's start. Office of the Presiding Disciplinary Judge. Filed February 25th, 2026. C. Lopez, for fuck's sake, no. Disciplinary. For fuck's sake. Well, Mo,
Disciplinary.
help.
Disciplinary. Well, I was trying not to jump in because I have that like Tourette's-y thing where I just want to say words. So I'm trying to be better at that. Disciplinary.
Okay, thank you. James D. Lee, Craig Henley, Senior Bar Counsel, State Bar of Arizona. Before the presiding disciplinary. Yeah, what she said. Judge, in the matter of a member of the State Bar of Arizona, David S. Gingras, bar number this, respondent, amended complaint. That number. Amended complaint is made against respondent as follows. Introduction. 1. Respondent represented Laura Owens in Maricopa County Superior Court regarding a motion for sanctions filed against her in a paternity case she had filed. After being hired by Owens, respondent became aware, based on his investigation and research, that she had made contradictory statements about her actions and had altered at least one medical record. 3. Despite being aware that... What?
Do you want to alternate pages or?
Yeah, sure.
Didn't know.
Yeah, something like that. Yeah.
Well, I was just thinking that way we don't, ruin your voice. Let's see. 3, despite being aware that Owens had given contradictory versions of the events and altered at least one medical report, respondent failed to withdraw as counsel for Owens or alternatively failed to diligently investigate and research relevant facts, pursuant claims which were without merit, prepared an affidavit for Owens to sign that included false information, failed to take steps to address false statements that Owens made during her deposition and 2 hearings, and presented Owens' false testimony to the court. During the period of representation, respondent failed to comply with a court order directing him not to disclose outside of counsel for the parties, quote, any medical or other documentations, exhibits, medical records, etc., disclosed between the parties. 5. During the period of representation, respondent took steps to prevent Michael Maraschini, a potentially adverse witness, from appearing and testifying at a hearing held on June 10th, 2024. 6. During the period of representation, respondent made public disparaging remarks on social media about members of the public and Maricopa County Superior Court Judge Julie Mata, who presided over paternity case filed by Owens. Yeah, don't do that.
No, don't do that.
Number 7, during the period of representation, respondent filed and pursued a non-meritorious appeal.
General allegations. 8. At all times relevant. Respondent was licensed to practice law in Arizona, having been admitted to practice law in Arizona on October 21st, 2004. Thank you, Rosalind, for $10, just because. That brings us to $15 combined, and $35 towards the first spin on the Wheel of Regrets. Yay! Thank you, Rosalind. Count 1. File knows, all the numbers. On August 1st, 2023, Laura Owens filed, pro se, a petition for court order for paternity and legal decision-making, parenting time, and child support. Quote, petition for court order for paternity against Clayton Eckert. In response, matter of Owens and Eckert, Maricopa County Superior Court, number that, hereafter, the paternity case. 10. The petition for court order for paternity alleged that Owens had become pregnant by Eckert. Who filed this disciplinary action? These two.
Now, were those opposing counsel for Clayton Eckert, or were those people that just saw what he was doing? Since I'm not...
This was... everybody can file complaints, and then these two are the ones who collect everything, compiles them in the correct format, if they choose to proceed.
All right.
The petition for court order for paternity, on September 14th, 2023, prior to respondent's involvement in the paternity case, Owens filed pro se an expedited motion to seal court record, asking the court to seal the entire record in the paternity case. Owens attached to that expedited motion to seal court record copies of several email messages from Eckert to Owens in which he sought evidence that she was pregnant. Eckert asserted in email messages that Owens A. was not pregnant by him, B. had never undergone an ultrasound, C. had offered illogical excuses to delay testing, and D. had provided him with a sonogram that had been created from an image on the internet.
Oh, the Fiverr sonogram. Oh my goodness gracious.
My God, yeah.
Let's see. 14. Among the email messages attached to expedited ! Motion to seal court record was a July 25th, 2023 email message from Eckert to Owens, which reflected that Eckert believed that Owens had provided him with a false sonogram. 15. The expedited ! Motion to seal court record indicated that Owens had failed to provide Eckert with evidence that she was in fact pregnant by Eckert. So you would think all of these things would need to be done for a paternity test.
Yeah. you would imagine so.
16. Owens, September 14th, 2023 expedited motion to seal court record and other documents in the court record, including Eckert's email messages to Owens, replaced respondent on notice that he needed to be diligent in A, ensuring that Owens was truthful about her health, alleged pregnancy, medical records, and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Eckert was the father. 17. Respondent had a duty to diligently investigate and research everything that Owens told him or provided to him. 18. Respondent failed to diligently investigate and or research Owens' allegations to determine whether her statements to him opposing counsel and the court were truthful, or that the sonogram provided to him and used during a court hearing on June 10th, 2024, was an image created by an ultrasound performed on Owens.
Yeah, as an attorney, when you are handed things, you have to perform due diligence. Is this something I can show to the court as an officer of the court? He didn't. He just presented it as truth of the matter asserted and stuck to it, even though it became quite apparent at the end that, this is horse shit.
Well, and as a lawyer, you're considered an officer of the court, so you are able to, kind of authenticate certain things, like I certify as an officer of the court, such and such. That's a privilege. You can't abuse that. I mean,
yeah.
And look, law is all about it's all
He-
about making the fact patterns fit your argument, but there's bending your argument to fit the facts, and then there's breaking the rules.
Yeah. I mean, if you have bad information, you avoid the bad information and try to find the positive things, but you can't present knowingly false things to the court as an officer to the court. And you can't claim ignorance because you have a duty as an officer to the court to perform due diligence. Hi, Tammy. Who filed the bar complaint? This bar complaint is something two attorneys who works for the bar have compiled due to probably people have emailed the state bar a lot. Some with just, hey, check this guy out. Others, here's a list. And they have done their due diligence by compiling everything into one motion. So this is what we are reading right now. All right. On January 3rd, 2024, Eckert's counsel filed a motion for sanctions pursuant to Rule 26 of the Arizona Rules of Family Law Procedure, in which he requested that Owens be sanctioned for filing the petition for court order for paternity and later documents for an improper purpose and without medical evidence to support her claim that she was pregnant. Eckert's January 3rd, 2024 motion for sanctions pursuant to Rule 26 placed respondent on notice that Eckert had claimed that Owens was not pregnant, which created a duty on his part to ensure that his investigation and research thoroughly addressed everything that Owens told him or provided to him. On February 21st, 2024, Judge Mada issued a minute entry order scheduling a hearing in the paternity case on June 10th, 2024 to address the issue of sanctions and attorney's fees related to the paternity case filed by Owens. On March 11th, 2024, Eckert's counsel filed a motion to compel, which stated in part that Owens had testified at a deposition that she had altered a sonogram, falsely claiming it came from Southwest Medical Imaging. Based on the March 11th, 2024 motion to compel, respondent was once again placed on notice that he needed to be diligent in A, ensuring that Owens was truthful about her health, alleged pregnancy, medical records and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Eckert was the father.
See, during or about March 2024, Owens hired respondent to represent her regarding the motion for sanctions pursuant to Rule 26. On March 25th, 2024, respondent filed a notice of appearance on Owens' behalf in the paternity case. Upon agreeing to represent Owens, respondents had the duty in preparing her defense to the motion for sanctions pursuant to Rule 26 and represent her at the June 10th, 2024 hearing to A, diligently investigate and research both parties' assertions and documentation, B, carefully reviewed the entire court record in the paternity case and related cases between Owens and Eckert. C, review the file provided to him by Owens' former counsel. D, review the information and documents provided to him by Eckert's counsel. And E, review other information that came to his attention. On March 26, 2024, Eckert's counsel filed a motion for relief from judgment based on fraud, hereafter motion for relief from judgment in the matter of Owens and Eckert, Maricopa County Superior Court, a lot of numbers, and an order of protection case. That March 26, 2024 motion for relief of judgment stated in part, on October 6, 2023 and October 25, 2023, Plaintiff Owens committed fraud when she filed her underlying petition for order of protection and then testified before Judge Duty under the fraudulent pretense that she was pregnant with defendant Eckert's twins, and defendant Eckert was cyberbullying her by posting her medical records online. To be clear, Plaintiff Owens was never pregnant by defendant Eckert, as they did not have penetrative sexual intercourse. You know, of all the things I thought I'd be reading in a legal document, penetrative intercourse was not on my bingo card, but I'm glad that it happened. Bucket list I didn't even know I wanted to achieve. Achievement unlocked.
Bold typeface and underlines in original. 29. That motion for relief from judgment further stated that Owens had admitted during her deposition that she had modified the medical records, which the court relied upon to grant an order of protection. That motion for relief from judgment noted that Owens had, quote, provided no verifiable medical evidence to support her alleged twin pregnancy, and had admitted that the ultrasound at the core of this court's basis for granting the protection orders was de facto fraudulent. Underlines and italics in original. That motion for relief from judgment contained additional information relevant to the paternity case. That motion for relief from judgment again placed respondent on notice that he needed to be diligent in A, ensuring that Owens was truthful about her health, alleged pregnancy, medical records, and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Eckert was the father. Those issues were relevant to the motion for sanctions pursuant to Rule 26. On April 9th, 2024, respondent filed a notice of appearance and notice regarding pending motion on Owens' behalf in the order of protection case number.
Let's see. On April 22nd and May 9th, 2024, respondent provided Eckert's counsel with supplemental disclosure statements that failed to adequately address Owens' changing version of events. On June 10th, 2024, Judge Mata presided over a hearing to address Eckert's request for sanctions and attorney fees. During that June 10th, 2024 hearing, Owens provided false testimony about matters pertaining to her alleged pregnancy. Respondent failed to correct or clarify Owens' false testimony during direct examination or redirect examination. On June 18th, 2024, Judge Mata entered an under advisement ruling regarding the June 10th hearing, or 2024 hearing, in which she found that I, Owens, failed to meet the burden of clear, convincing evidence that Eckert was the father of Owens' alleged pregnancy. 2, that Owens acted unreasonably when she initiated litigation without basis or merit. Petition for court order for paternity was premature at best. 4, Owens repetitively failed to comply with Family Law Rule 49 regarding disclosure, even on order of this court. Now, Judge Mata did not find that the respondent had failed to comply with disclosure or discovery rules. let's see. The under advisement ruling did not specify the disclosure violations other than to state that Owens presented new information about an ultrasound at the hearing and testified on the day of the hearing that she had anonymously sought care at a Planned Parenthood location in Los Angeles, which has never been disclosed.
Yeah.
Ooh, talk footnotes to me. I'm such a nerd. I'm like, oh, they have footnotes.
And thank you to Lisa B. $10. Thanks for the coverage. Thank you. Thank you. That brings us halfway to the first spin on the Wheel of Regrets. Yeah, this... when they couldn't find anyone, any Planned Parenthood in the county where she originally said she thought, on the stand, she just made it up. Well, I went to Los Angeles.
Yeah, and we learned, I think, that Planned Parenthood didn't accept aliases or, false identities because she was like, yeah, no, I went in as chair.
Yeah, I went in there anonymously. And no, there's no such thing.
Laura, I don't know who never told you this in life, but the rest of us don't care that much about you. Like, we don't follow you. Like me personally, I still barely remember who you are. Now, the people you victimized remember you, but they also would only GPS track you to stay away from you, not to follow you.
Yeah. I mean, this is one of these people that should have a reverse, what do you call it, when they are looking for missing children?
Oh, an Amber Alert?
Yeah, a reversed Amber Alert. Oh no, she's there. Go away.
She needs a guardian ad datum. She needs like a matchmaker to get her just married the heck off. Like if we decide to let her be out of prison.
Thank you, Marielle, because you can't cover this sober. Thank you so much. All right, more than half.
Woohoo!
And thank you to Salty Sea becoming a member. Let's see. Now we are $33 in and only $17 towards the first spin on the Wheel of Regrets. Thank you so much. And now Salty Sea has access to all my members-only content and members-only emojis here on YouTube. Thank you so much. Or the court's April 4th, 2024 order compelling disclosure. Owens acknowledged that she altered HCG test results, footnote 2, and ultrasound and sonogram, footnote 3. Footnote 2. An HCG, human
chorionic gonadotropin
test is a medical procedure used to detect pregnancy. An ultrasound is the medical imaging technique. A sonogram is the image produced by an ultrasound.
Can I hire myself out as a pregnancy expert? Like 6 times, I feel like I should get like state of Michigan, or not Michigan, Massachusetts. Now, I'm not going to go there for less than $300K, but if you need an expert, I'm here.
Yeah, reverse Amber Alert. Warning, danger.
Yeah.
Sip your fly and run away.
Yes.
What are we all doing tonight? Not making.
I don't know.
Yeah.
We should hang out, Dave. You can read this abomination of a lawyer takedown with us.
Yeah, you Dave can do all the Latin names.
Yeah, all the counting and such.
Yeah. Blah, blah, blah. 4. The petition was not filed in good faith. The petition was not grounded in fact or based on law. The petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. 6. 7. Owens, quote, provided false testimony as to the viability of the pregnancy in the paternity case, the order of protection case, and an injunction against harassment case filed by Eckert, and 7 again. Owens knowingly presented a false claim and knowingly violated a court order compelling disclosure or discovery such that an award of attorney fees and costs is appropriate under Rs 25.415. Arizona rule of something.
I think we should just name it arse.
Yeah, Rs. Yeah. This bit here, for you who are completely new to all of this, she first claimed October that she was still 100% pregnant. Then she claimed miscarriage. But then she found out that in Arizona, if you're past 20 weeks, it's no longer a miscarriage, it's a stillbirth.
Yeah.
And you need to provide all the doctor's notes. And all of a sudden, with the help of Mr. Gingras, she invented. No, it happened back in June, all of a sudden.
I'm
Yeah.
still stuck on the fact that this man was sitting in his office, I don't know, watching Matlock, and Laura Owens comes tweaking in, jittery and such, and she sits in and she's like, do I have a case for you?
Yeah.
I am pregnant with twins. And he's like, how did this happen? She's like, well, it is a miracle. And and then he's like, okay, this sounds a little crazy, but he's like, you know what? She has money. I'm going to take a retainer because, money is money. And then he gets the paperwork and he's still like,
Yeah. She's as crazy as I am.
Yeah, I would like, oh, I got the retainer and the paperwork. Well, I have questions, all of them.
Which I will never ask because I want the monies.
Well, yeah, but I also want to keep my license.
Yeah. Yeah.
She's a moron with money. I can keep her retaining me for years.
Yeah, until she
allegedly in Minecraft.
Yeah, until she didn't have any money, and he still represents her because now, out of self-preservation, or tries to represent her out of self-preservation, because as long as he can claim some representation, there's information that he might or might not
claim competent representation.
No,
or effective representation.
He's trying, but he's failing. He is so failing. On August 16th, 2024, Judge Mada issued an order regarding application for attorney's fees and costs, directing Owens to pay a total of $149,219.76 in attorney's fees and costs to Eckert within 180 days. Responded, violated Judge Mada's February 21st, 2024 order. All allegations set forth above are incorporated herein as if set forth in full.
Okay, let's see. On February 21st, 2024, Judge Mada issued a minute entry order in the paternity case regarding the status conference held on that date, which stated in part, it is further ordered denying counsel for petitioner Laura Owens' oral motion to reconsider regarding the ruling concerning petitioner's motion for confidentiality. Further discussion is held regarding discovery and disclosure. Counsel for petitioner Owens addresses the court with an oral request to have the court order his client provide medical records pertaining to the pregnancy only. Let the record further reflect that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc., disclosed between the parties. It is further ordered that the records be disclosed dating back to August 2020. Capitalization and boldface in original. On April 1st, 2024, respondent filed a motion for extension of time to respond to respondent Eckert's March 11th, 2024 motion to compel. Hereinafter, motion for extension of time to respond, to which he attached a declaration that he signed. Respondent including the following in his April 1st, 2024 motion for extension of time to respond. A reproduction of a portion of Owens' lab results history report dated June 1st, 2023. Would that be before or after Adobe Acrobat? Like, B, a portion of an unable to process request notice from Banter Health regarding Owens, and C, a portion of a receipt from Banner Urgent Care regarding Owens dated June 1st, 2023.
44. Respondent included the following in his April 1st, 2024 declaration. A reproduction of a portion of Owens' lab result history report dated June 1st, 2023. A portion of a receipt from Banner Urgent Care regarding Owens dated June 1st, 2023. A portion of unable to process request notice from Banner Health regarding Owens. And D, copies of messages between Owens and Dr. Joshua McCool. 45. Respondent knowingly violated Judge Mada's order by disclosing information and documents related to Owens' medical records in his motion for extension of time to respond and declaration. Yeah, up here in the order. No party shall disclose outside of themselves any medical or other documentation disclosed between the parties.
But it didn't specifically say David Gingras, so he might not have felt specifically named efficiently, or sufficiently named.
Yeah. Respondent failed to file a motion to seal either his April 1st, 2024 motion for extension of time or his declaration, despite Judge Mada's February 21st, 2024 minute entry order. On April 4th, 2024, respondent posted the following on his law office blog. Quote, on October 16th, 2023, Laura had a blood test done at the lab. Want to guess what the result showed? Pregnant, but don't take my word for it. The report can be viewed right here.
He passed the bar?
Motion to compel bacon animal toy squeeze. Motion granted. Thank you so much. Thank you, Jinx, for your Danish krona 17, which is about 24 Swedish krona, which is about just over $2. Thank you. Gets us to $15 to the first spin on the Wheel of Regrets. The underlined text was a link to Owens' October 17th, 2023 Sonora Quest Laboratories medical report. Respondent knowingly violated Judge Mada's February 21st, 2024 order by including a link on his blog that led to Owens' Sonora Quest Laboratories medical report. Your turn.
Oh, okay. Let's see here. Also on April 4th, 2024, Greg Woodnick, Eckerd's counsel, sent an email message to respondent, which stated in part, quote, I am also not certain why you are publishing court documents and your client's personal medical records contrary to a court order. Laura Owens needs to comply with the order and provide disclosure, end quote. That email message from attorney Woodnick placed respondent on notice that he needed to take some action to seal Owens' medical information and documents. Despite notice from Eckerd's counsel regarding his violation of Judge Mada's February 21st, 2024 order, respondent failed to file a motion to seal Owens' medical information and documents that he had disclosed in his April 1st, 2024 motion for extension of time to respond and attached declaration. On or about April 19th, 2024, respondent posted on his law office blog and or other social media the content set forth in Exhibit A to this complaint, which included a portion of one of Owen's medical reports. On April 26, 2024, a Friday, at approximately 5:52 p.m., respondent filed petitioner's response to respondent's amended motion for relief based on fraud. Hereafter, April 26, 2024 response. Did this man do anything other than like file motions to extend motions of extended motions from years past? I mean,
That's about it. That's what he did.
okay.
Yeah. Respondents filing on the April 26, 2024 response did not, at the time he filed it, become a matter of public record. That April 26, 2024 response included a summary of portions of Dr. Dean's and Dr. Justitia Linde's expert report, which they had prepared for Eckert under the heading, Miss Owens was pregnant.
Did he write it in Comic Sans? Please tell me the report was in Comic Sans.
I'm reading all of his motions as if they were with Comic Sans because it makes
Thank
them
you.
bearable. Under the heading, this discuss Dr. Dean's and Dr. Justitia Linde's expert report, and quotation taken from Dr. Dean's and her expert report appeared near the bottom of page 10. Attached to that April 26, the response was a copy of Dr. Dean's and her expert report and Dr. Dean's CV. That response discussed the report provided by Owen's medical expert, Dr. Michael Medchill. Attached to that April 26 response was a copy of Dr. Medchill's expert report and CV. Also attached to that response were copies of Owen's medical records and other documents relevant to Eckert's claims, e.g. Owen's affidavit, dated April 16th, included information from Owen's medical records and portions of her medical records reports. At approximately noon on Saturday, April 27th, 2024, respondent posted on his publicly accessible personal X, formerly Twitter account, his law firm website and or other social media, a link to, among other things, his April 26 response, which included portions of Owen's medical information and documents.
Doing a banner job of lawyering there.
I mean, Mr. Gingras, just hand over your bar card. Just go away.
Yeah, I mean, you do have to follow certain rules. I mean, the fun of law is figuring out how to get your argument to fit in the parameter of those rules. I mean,
Yeah.
that's kind of the fun, nerdy part for me is, oh, okay, I have these bad facts, but how can I strategize to, let's see here.
Yeah, but he does not.
No. Respondent knowingly violated Judge Mata's February 21st, 2024 minute entry order by posting Owen's medical information and documents on his X and other social media. On April 29th, 2024, the Maricopa County Superior Court Clerk's Office docketed respondent's April 26, 2024 response, at which time that document became a public record available to the public through the clerk's office. Neither Dr. Samantha Dean nor Dr. Faye Justica Lind consented to the publication of their expert report because it contained a review of Owens's private medical records, which were intended solely for the attorney and the court's review. At no time did respondent file a motion to seal A, Owen's medical information or documents, or B, his April 26, 2024 response, despite Judge Mata's February 21st, 2024 minute entry order. Ethical violations are related to respondent's violation of Judge Mata's February 21st, 2024 order. Yeah, you shouldn't violate multiple orders.
This is one order multiple times, but there are more. There are more.
Of course there are.
Oh, is it me? By engaging in the conduct set forth above, respondent violated.
ER 3.4. Oh, am I back or?
Are you back?
Yes, I think so.
Yeah, okay. Continue.
Let's see. By making extrajudicial statements that he knew or reasonably should have known would be disseminated by means of public communication and would have a substantial likelihood of materially prejudicing the paternity case. ER for 4A, by using means that had no substantial purpose other than to embarrass, delay, or burden any other person, and Rule 54C, Arizona R sub T, by knowingly violating Judge Mata's February 21st, 2024 order. Yeah, don't do that.
Yeah, that section was only his violations against that order.
Oh, good night, nurse.
Yeah, and there were a lot. And we are just on page 15 out of 51. Now we're going into respondents' efforts to preclude Michael Maricini from testifying on June 10th, 2024. Yeah, Laura Owens had a TRO against Michael Maricini, but those are overridden by subpoena. Legal subpoenas overrides all of those. So he was legally there in order to testify. And for you who haven't heard this one is going to be wild. 65. All allegations set forth above are incorporated herein as if set forth in full. Laura Owens obtained a domestic violence restraining order, DVRO, against Michael Maricini in California, which was renewed and extended to September 11th, 2025. And I covered when she fucked up that completely by first not showing up to court, but trying to call in and say, oh, I'm with the help of some nurse practitioner. Oh, I'm so sick. I'm so ill. I'm dying. I'm bleeding out of every hole in my body. Which made the judge, yeah, let's postpone this 2 weeks so you can get health care. About 2 days later, she's caught on camera on a horse jumping show.
Yeah, I haven't been pregnant in a while, but I do know that horse riding was something I was not encouraged to do. Now, I didn't have many opportunities to play with horses during any of my pregnancies, but I do remember that being on kind of the things I wasn't supposed to do.
Let's see if I can. Media. Documents, no. Coverage, no. No. Well, we can bring it up later. There's a video of her on a horse jumping show where she competed on several days. So not so dying. And then when it was time for 2 weeks later to actually show up for the permanent restraining order, she did not show up at all. So it was dismissed. And now she has appealed that dismissal. And that's, yeah, it's so stupid. Yeah, she competed in the under 14 division and against children with disabilities. And by the way, she won. You can't make this shit up. It is so insane. You really can't make this shit up.
There are so many jokes that it would nuke your channel, and I'm trying.
It's she more or less, to make a comparison for us men. Imagine she went on a slapping contest, and imagine a man entering himself in a under 14 slapping contest and goes up against children and people with disabilities, and you win. That's not
but
much to cheer for.
I would be shocked because of the amount of money that goes into horse riding, that horse riding parents, like horse moms, wouldn't have kicked her ass for taking the trophy away from their kid.
Yeah, but she was allowed to, because you can compete in lower classes as an adult, apparently, in horse riding. And it's
Well, yeah, she is emotionally 14, but I mean,
yeah, she works hard for her money, not hard enough. She works for no money. Technically, she is an adult. This case is getting harder and harder to swallow.
poor Clayton. Poor Clayton.
Poor
Poor
Clayton.
every man that's been victimized by her.
Yeah.
And now she's going off after random, really nice. I haven't met Rob a whole lot, but he seems like the nicest. Like, I'm a cynical butthole, and he's like the nicest person, and I'm over here like all cynical, and she's being mean to him.
Yeah. Now, he has a flavor of streaming. He uses words that sometimes makes mine go pale in comparison, but that's still just reporting. But sadly, because he appealed the restraining order and somehow he lost. So now there is an active restraining order.
So will that preclude him from going to her trial and things like that as well?
He is only precluded from active contact with her, which means as long as he does, which was what he did to begin with, he can still make content, allegedly, about her.
Oh, okay.
But the court regarded some of these things as at her, despite her in her own filing said she had to find these things or was made aware it existed. So, but probably what happened is that judge on the side of caution. And that is what Laura Owens is counting on in every filing, that judges will grant it on the side of caution. Rob who? His channel name is Hey Rob! Exclamation point. And and to stay 30 yards away from her. Okay, you can technically attend her court hearings, but not if it's in a small courtroom. Yeah. So sadly, she won because she uses lawfare to win. All right.
I'm sorry. It was me.
No.
Is it you or
no?
Okay.
It's me. I barely started.
Oh, okay. I was like, wait, where are we?
We went here and then we talked about the restraining order and stuff and what happened. That DVRO required Maricini to remain at least 100 yards away from Owens. During the course of the paternity case, Eckert's counsel disclosed to respondent that he intended to call Maricini as a witness. A few weeks later, just before the discovery deadline, Eckert's counsel informed respondent that, contrary to information he, respondent, had been given by Maricini's California attorney, Maricini would appear and testify at the hearing. Yeah, he was first reluctant, of course, because he doesn't want anything to do with Laura Owens. She got the original DVRO 10 years ago. And she keeps harassed him ever since. Neither Eckert's counsel nor Maricini nor respondent filed a motion in the San Francisco County Superior Court to modify the terms of the DVRO to allow Maricini to testify in Arizona. On April 30th, 2024, respondent filed a motion in limine, asking the court to preclude Maricini from testifying because A, his testimony would elicit improper Rule 404B evidence, and B, Eckes' counsel had allegedly failed to comply with the disclosure rules regarding the nature of Maricini's testimony. Respondent did not reference the existence of the DVRO in that motion in limine. Also on April 30th, 2024, respondent filed an emergency motion to strike a request to immediate telephonic scheduling conference, hereafter emergency motion to strike, which included a request for an immediate scheduling conference to address whether Eckes' counsel would be permitted to call 3 newly disclosed witnesses, one of whom was Maricini, at the June 10th, 2024 hearing. On or about May 7th, 2024, Eckes' attorney subpoenaed Maricini to testify as a Rule 404B witness at the hearing scheduled for June 10th, 2024. Maricini was aware of the paternity case and agreed to voluntarily appear and testify in Arizona at the June 10th hearing. In an email message from respondent to Eckes' counsel on May 8th, 2024, respondent stated, now I have to imitate what I believe to be David Gingras' voice.
This goes without saying, but to the extent I suggest that Mike would be arrested if he comes to court in Arizona. That suggestion is completely withdrawn. I only said that because I didn't want Mike to show up without giving me the chance to at least interview him, as I would with any normal witness. As long as Mike agrees to have a reasonable call to answer some questions, I would stipulate and agree that his appearance in Arizona is not a violation of anything and will not expose him to arrest or other legal consequences.
I think I was pretty close there. I mean, I think I'm better than Dali.
I think so.
Yeah.
Let's see. 76, Maricini did not make himself available to the for the respondent to interview. On May 21st, 2024, Judge Mata issued a minute entry order denying respondent's motion in limine. On June 3rd, 2024, to preserve the issue of the propriety of Maricini propriety. Testifying at the June 10th, 2024 hearing, respondent filed a pretrial statement that addressed that issue. In that pretrial statement, respondent explained that it would be a crime for Maricini to violate the California DVRO and that any violation of the order by Maricini would subject him to arrest. That pretrial statement also stated that, quote, the issue has been reported to court security by undersigned counsel respondent, who has requested that Mr. Maricini be arrested if he violates the DVRO as the law requires, end quote. Also on June 3rd, 2024, respondent called security personnel at the Maricopa County Superior Court and spoke with Officer Gibbs, informing him that Owens had a valid DVRO from California and that she was concerned that he intended to violate the order by appearing at trial.
Yeah, and remember with what the respondent said on May 8th, that he wouldn't do anything. And on June 3rd, he tried to have Mr. Maricini arrested. And in motions after, he has continued to say it was an illegal subpoena. It's so stupid. Also on June 3rd, respondent sent an email message to Officer Gibbs, to which he attached a copy of the California DVRO. Respondent's June 3rd email message to Officer Gibbs stated that, quote, court approval for Maricini to appear at trial has not been granted, and the DVRO contains no exceptions for in-person contact like this, end quote.
Okay, wait, Nick, I'm not a lawyer, but I would assume that even if you have a restraining order, you still have to appear at court for, let's say, like the current ongoing DV trial. So aren't there exceptions for court? I
Yeah.
mean, I'm not a
He had a legal subpoena from the defense. There's really no need, unless he tries to write a motion in limine to the court, which and next point was denied by the court, his motion in limine to prevent Maraschini from testifying.
yeah.
So he was allowed to go there. And
Well, that's what I kind of figured. I mean, not being a lawyer, but I assumed that, a protective order didn't keep you out of court. Otherwise, everyone would have a bench warrant.
yeah. So even though Mr. Gingras knew it was a legal subpoena, that he was denied the motion in limine, he still tried to have Mr. Maraschini arrested. Yeah.
Such a,
He's
it's
a
lawyers like him that give the real, stereotype of the slimy, greasy, underhanded. And there's no strategy in this. There's no mental, exercise in this. This is all underhanded. I mean, I would be more impressed if he was able to take this terrible case and convince Laura to not go with it. That would be a sign of real intelligence if you could get a stubborn, recalcitrant, person like her to stop being a moron.
Instead, he enforced her moronic tendencies. Judge Madda had previously denied respondents' motion in limine to prevent Maraschini from testifying, but had not yet ruled on his objection to Maraschini's testimony, which is set forth in a petitioner's pre-trial statement filed on June 3rd, 2024. Yeah, but she had not yet ruled on it, but she still denied your motion in limine, which means until she has ruled, the previous ruling applies. He's not precluded. Respondent also claimed in his June 3 email message to Officer Gibbs that if Maraschini appeared in court, he would clearly violate the DVRO. And this is false on its face. Respondent additionally claimed in his June 3 email message to Officer Gibbs that, quote, due to the short time before trial, he cannot raise this issue with Judge Madda before next week. He lied to a cop.
Yeah, I just don't see him having a license after all of this.
On June 4th, Eccles counsel sent an email message to Officer Gibbs and Judge Madda's court stating that a valid subpoena had been issued for Maraschini's appearance. Respondent was copied on that email message. Eccles counsel suggested in that June 4th email message to Officer Gibbs that respondent's act of requesting law enforcement to enforce Owens' DVRO qualified as an attempt to intimidate a witness, as set forth in RS 132802.
Let's see. 89. Sometime prior to June 10th, 2024 hearing, respondent sent an email message to Maraschini's attorney in California, informing her that because of the DVRO, Maraschini would be arrested if he attended the June 10th, 2024 trial. On the morning of June 10th, 2024, when Owen saw Maraschini in the parking lot, respondent contacted court security personnel, but he was informed that they were unable to help. Shortly thereafter, respondent called 911. What in the flaming moron?
Yeah.
This is why aliens won't give us futuristic technology. Gingras, I blame you. I'm not even going to say your name right because I just don't care about the extra R in there. Called 911 from the courthouse parking lot to report Owen's concerns about Maraschini's ostensible violation of the DVRO. Prior to the commencement of the June 10th, 2024 hearing, court security personnel and/or the Maricopa County Sheriff's Office informed the court that respondent had called 911 from the parking lot of the Northeast Justice Court building and attempted to have Maraschini arrested for violation of the DVRO. Judge Mata or a member of her staff through the court security personnel and or MCSO informed responding police officers that Maraschini was responding to a valid subpoena and was not to be detained prior to his testimony. On June 10th, 2024, court security personnel escorted respondent and Owens from the parking lot to the courtroom prior to the hearing.
Yeah, because they were so afraid.
Oh, good Lord.
At the June 10th hearing, Judge Mata allowed respondent to argue on the record, before any witnesses were called, his objection to Maraschini's testifying. Respondent argued non-disclosure as basis for precluding Maraschini's testimony, as well as the existence of the DVRO, stating, "The second issue, Your Honor, deals with this California court restraining order. I think you have a copy of it. It's one of our trial exhibits. We have court record from the state of California that prohibits Mr. Maraschini from being within 100 yards of Miss Owens. He's in violation of it right now. There is no exception for court appearances. He is so terrified that he may not be able to sit here during this trial." She can stand up, then fuck do I care. "Under the full faith and credit to us of the U.S. Constitution."
She can ride a horse while bleeding from all orifice.
Yeah.
She can deal with a little terror.
"This court is required to enforce what that order as it is written. You can't change it. You can't modify it. You can't disregard it. And yet here we are." Judge Mata affirmed her prior ruling, allowing Maraschini to testify. She more or less told Gingras, "Go fuck yourself. This is my court." Maraschini was sworn to testify in court on June 10th, but never testified. They ran out of time because Laura Owens was on the stand spewing garbage for way too long under the baseball directions of Mr. Gingras,
Oh, good Lord.
to the extent that Clayton's attorney saw it and put himself in the way, in between them, at what point Laura Owens started to cry.
Well, she doesn't have boobs. I mean, how is she going to distract people? She's all of 10 pounds.
She weighs less than a photo of herself. I mean, seriously.
Yeah.
Violations based on respondents' efforts to preclude Michael Maraschini from testifying on June 10th. Based on the conduct set forth above, respondent violated ER 34A and ER 84A by unlawfully attempting to obstruct Clayton Eckert's access to Maraschini's testimony, ER 44A by using means that had no substantial purpose other than to embarrass, delay, or burden Eckert or his counsel, and ER 84D by engaging in conduct prejudicial to the administration of justice.
Let's see. Respondents' disparaging comments about Maricopa County Superior Court Judge Julie Mata. Yeah, this one I have seen.
Yeah.
Good God, what a fucking thing,
Yeah.
like act of hubris, like just ooh. All allegations set forth above are incorporated herein as if set forth in full. Respondent knowingly made unprofessional, disparaging, and inappropriate comments about Judge Mata's qualifications and or integrity in documents filed with the court and in posts he made on social media accounts. First instant, Judge Mata's father's attendance at June 10th, 2024 hearing. Good God.
Yeah.
On July 8th, 2024, 20 days after Judge Mata entered her under advisement ruling regarding the June 10th, 2024 hearing, respondent filed a notice of change of judge for cause memorandum and affidavit in support, hereafter notice of change of judge for cause, which was unprofessional and inappropriately disparaging of Judge Mata. For example, respondent stated the following in the notice.
It is difficult to imagine a more disrespectful, disreputable, and disgraceful act for any judge to commit than inviting her father to attend a high-profile trial in support of a party, while also privately engaging in prohibited ex parte discussions about the case with her father. See side note or footnote 4. According to internet reports, Judge Amata's father attended the July 10th, 2024 hearing, over which Judge Mata presided and was present in the overflow courtroom where the hearing was live streamed. Idiot. These actions make a mockery of this proceedings, as shown in video clips submitted herewith. Clayton's supporters gleefully celebrated Judge Mata's father's participation in this case, even going so far as to laughingly ask people not to spread information about his participation because after all, we don't need a mistrial here. For once, those followers were exactly right. The conduct of Judge Mata and her father absolutely warrant a mistrial, or more accurately, a retrial before a different and unbiased judge. This shameful conduct by Judge Mata not only violated Laura Owens' rights, but it raises serious questions regarding Judge Mata's fitness as a judge of the Superior Court. Any reasonable objective observer in Laura's position would be justified in wondering. We all wonder how she thought she was going to get away with this, sir. We've been wondering this entire time. Was my case fairly decided on the evidence, or was Judge Mata simply trying to impress her father? Look at me, Daddy. I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. Hee hee.
He actually wrote this in
Please tell me he
a
was
legal
still like he
document.
was barely functional. But I will allow drunken stupidity to be the only cause of this. Also, I think my face is stuck like that. If I get wrinkles, I'm suing. Well, he's probably not gonna have any money left.
Yeah.
Oh, I'm sorry. There's more. There's
Yeah.
more. It's Mein Kampf of sadness.
Yeah.
Assuming the published allegations of Judge Mata are true, as documented on video by Clayton Eckert's own followers, this proves that Judge Mata separately violated Rule 2.9a of the Code of Judicial Conduct, and Judge Mata's blatant, pervasive disregard for her ethical duties and her disrespect for Laura's fundamental rights help explain the judge's numerous and otherwise hitherto inexplicable adverse rulings during this action.
Italics, underline, and parentheticals in original. Second instance. Oh, he's not done.
Oh, dear God. He just will not shut up. Bless him, for I love reading this utter insanity.
Screwed up form of final judgment. Sometime prior to September 3rd, which was during the pendency of Owens' appeal from Judge Mata's under advisement ruling, dated June 18th. Respondent posted on his law firm's or personal blog, X account, and or other social media the content set forth in Exhibit B to this complaint. Exhibit B. Let's see. Exhibit B from X. The notice of appeal must be filled within 30 days of the judgment. Annoyingly, but not surprisingly, Mata screwed up the form of final judgment. It doesn't contain stuff required by the rules. Shocker! We could ask her to fix this, but that would be a waste of time.
No one liked it? That's kind of sad. Like, I don't have a giant following on Twitter, but I at least get like one heart sometimes.
Yeah.
I feel bad for the poor guy. I mean, he's a moron, but at least his mom should make him feel special. Like,
second is, yeah, here it is.
yeah, we're at the second incident, not the
yeah.
fifth incident. Good God.
Respondents' comment above pertain to Judge Mala's inadvertent reference to an incorrect family law rule regarding the final judgment language in her June 18th under advisement ruling regarding the June 10th hearing. She referenced Rule 78B of the Arizona Rules of Family Law Procedure instead of Rule 78C. Oh no. She corrected that inadvertent error on February 18th after the Arizona Court of Appeals remanded the matter to Superior Court. Third instance.
Oh, good God. Sometime prior to September 3rd, 2024, during the pendency of Owens' appeal, respondent posted on his law firm's or personal blog X account or other social media the content set forth in Exhibit C to this complaint.
Okay, Exhibit C. Exhibit C.
Let's see. No, the judge commits a crime was completely unnecessary. See Law Cornell Education U.S. Code Text 18. Me explaining how this made Laura feel was entirely necessary, legal, and ethical. I hope no judge ever violates your rights and treats you this way. But if they did, how would you feel? Well, considering we don't rule on feelings, I don't think it would care. I wouldn't want the court to care about my feelings.
I have to.
I think we're almost.
Second.
Yeah.
No, it's here. Third. Yeah.
Okay. Let's see here. Okay. See. Respondent's reference to Judge Mata committing a crime pertaining to her alleged failure to enforce the DVRO against Maricini by allowing him to attend the June 10th, 2024 hearing and be within 100 yards of Owens. Fourth incident, internet posting of, quote, public warning, Judge Julie A. Mata, end quote. On December 16th, 2024, respondent posted on his law office blog website the content set forth in Exhibit D to this complaint. You are a blithering moron, sir.
Gingras Law Office, PLLC.
Yes.
Public warning, Judge Julie A. Mata. Do you have, as one word, a family law case in Maricopa County Superior Court? Is your case currently assigned to Judge Julie A. Mata? If so, one word, please read this extremely important message. If your family law case is currently assigned to Judge Mata, you should immediately.
How can you slur your typing? Like, that's impressive right there.
Immediately ask for your case to be reassigned to double space a new judge, double space judge. With only limited restrictions, there is on a rule of family law procedure allowed you to have a new judge colon E as one GNED with virtually no questions asked. But you can lose this valuable right. If you wait, pause too long, ... So please do yourself a favor. If your case is assigned to 10, Judge Mata, you should consider immediately asking for a new judge. I'm reading this as he has spelled it, as written. Here's why Judge Julie Mata has recently been accused of using internet research or decide cases assigned to her. This is absolutely illegal and unethical, and it can lead to heartbreaking results for your family and loved ones. ... In fact, in one recent complaint post on the robingroom.com, the author claims Judge Mala took his children away based on bogus information the judge found in a Google search.
We need to look up the robing room because I feel like that's on the hub. That is not
I don't think that
legitimate.
is an official complaint.
It feels like Reddit tried to be official.
This is absolutely heartbreaking and it's illegal. Folks, it is blatantly unlawful for a judge to decide your case based on something they found on an internet search. It is a, one word, clear violation of both the United States cons in
IUCN.
and Rule 2.9 of the Arizona Code of Judicial Conduct. The law only permits a judge to decide your case based on admissible facts and evidence submitted in court. That's not actually entirely true. But yeah.
You're God, he's so dumb. We're not even halfway through. What the hell? I don't know why this is tickling my funny bone, but good God. Which stated in part that, quote, Google is not a valid legal source of evidence. Did you read this yourself? Space, unless your case is assigned to Judge Mata, ellipses in original. Fifth instance, Judge Mata does not care about the rules. On December 10th, 2024, respondent recorded a podcast in which he stated the following. At 27 minutes, 25 seconds, if Judge Mata was a person who cared about the rules, she would have sanctioned Woodnick for making false statements about the law, and she would have referred him to the state bar like she did with me.
Okay, that was with Judge Mata.
Yes.
Well, violation related to respondents' disparaging comments about Judge Mata. Here they are going through what bar rules he broke. Based on the conduct set forth above, respondent violated ER 4.4a by using means that have no substantial purpose other than to embarrass or burden Judge Julie Mata. ER 8.2a by making a statement with reckless disregard as to its truth or falsity concerning Judge Mata's qualifications or integrity. ER 8.4d by engaging in conduct prejudicial to the administration of justice, and Rules 41b3 and 7 Arizona R sub CT by failing to maintain the respect due to the court and Judge Mata and engaging in unprofessional conduct, including by making public statements about Judge Mata's qualifications or integrity that were objectively false or made with a reckless disregard as to their truth or falsity. Next, disparaging comments about members of the public.
Am I mentioned? No, I'm too late to the thing. I will get a David mention one day. I really will.
Megan Fox maybe in here. I don't know. And Dave Neal and I haven't read this. So all of this is news to me. Well, not all of it is news, but how they put this document together.
Also, weren't there allegations of him using AI in some of his legal drafts and motions? Or is that in the Hales case? I get them mixed up.
I don't think. I mean, yeah.
As I said, I've been kind of out of the loop on all of these other trials you've been covering, so I could be mixing them up.
Yeah, Laura loves coverage about her. Maybe not. But,
can I pet a horse?
Hello. You know what this is? It's.
Don't give her any ideas, Nick.
2 bags of these.
Nick, now she's pregnant with quadruplets.
All allegations set forth above are incorporated herein as if set forth in full. On November 21st, respondent sent an email message to Laura Owens and copyright@reddit.com, in which he identified himself as a lawyer in Phoenix, Arizona, representing Owens in her case against Eckert. That November 21st email message, which respondent made available to Reddit employees when he sent it to copyright@reddit.com, stated in part, Clayton Eckers fans are generally speaking total fucking psychotic assholes.
Takes one to know one. Did he have to? He should be
Clayton's-
proud of us. We came up with a new
Yeah.
plan. I mean, for
Mm.
as stupid as we are, I mean, he should be proud that we've figured out with our crayons how to make a new plan.
Clayton's fans, being the total fucking assholes that they are, have come up with a new plan. Are we all assholes? Yes, we are assholes.
Yes.
At least we don't have... If somebody blows into Laura Owens' ear, it goes... I mean...
Yeah.
On December 4th, 2024, responded filed a request for subpoenas to identify infringers pursuant to 17 USC and supported declaration here after request for subpoenas. Respondent included a copy of his November 21st email message as Exhibit A to that request for subpoenas. Violation related to respondent's disparaging comments about members of the public. By engaging in the conduct set above, respondent violated Rule 41B7, Arizona R sub CT, by engaging in unprofessional conduct. Yeah, he tried to use copyright to get names from Reddit.
Who trusts Reddit for anything?
Who the fuck uses their actual name and email?
On Reddit?
Yeah.
Yeah.
Respondents' meritless claims, false information in an affidavit, and presentation of Owens' false testimony changing version of events. All allegations set forth above are incorporated herein as if set forth in full. Eckert's counsel deposed Laura Owens on March 1st, 2024, approximately 3 weeks before Owens hired respondent. During Owens' deposition, she testified that she had an ultrasound performed at Planned Parenthood at July 7th in Mission Viejo, California. B. Altered the California Planned Parenthood sonogram to say SMIL, Southwest Medical Imaging, instead of Planned Parenthood. C. Had gone to Planned Parenthood anonymously. D. Added her name to the sonogram. E. Not changed the date on the sonogram from July 2nd to July 7th. And F. Altered the sonogram at home using Adobe Acrobat.
Good Lord.
Now it's you.
On March 11th, 2024, Eckert's counsel filed a motion to compel the production of, among other things, the original records from Planned Parenthood Mission Viejo Health Center. On March 25th, 2024, respondent sent an email message to Eckert's counsel stating that he would take a, quote, trust but verify. With Owens? Like, I trust Congress more than I trust herpes more than I trust him. I verify Laura Owens.
Hey, Bruce.
Approach with Owens.
Hey, Bruce.
And that he would actively investigate every detail of what she said, looking for information that contradicted her statements. Does he have glaucoma? Is he blind? On March 27th, 2024, Eckert's counsel sent an email message to respondent stating that A. Owens' prior counsel had presented records to the court, including medical records and letters from law firms that were fabricated by Owens. B. Owens had, quote, misused court processes in multiple states to perpetuate the most bizarre of cons for relationships, end quote. And that C, 5 men had documented Owens faking pregnancies and fabricating medical records. On March...
At least 4 men that we know of.
The March 27th, 2024 letter from Eckert's counsel placed respondent on notice that he needed to be diligent in A, ensuring that Owens was truthful about...
What? You went to the LA Marathon Expo and already exhausted.
You went to a marathon. Yeah. I mean, that's more than I've done.
I only read that and I'm out of breath. I mean...
yeah. All right, let's see. Ensuring that Owens was truthful about anything? Her health, alleged pregnancy, medical records, and events, and D, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Eckert was the father.
On April
I
4th,
know the answer to that.
yeah. On April 4th, Judge Mada signed an order granting Eckert's motion to compel, directing the respondent to provide Eckert with the following, among other things, by 5 p.m. April 19th. All medical records for petitioner from Planned Parenthood Mission Viejo from on or about July 7th, 2023. That April 4th order placed respondent on notice that he had to diligently search for all of Owens' medical records at Planned Parenthood Mission Viejo from on or about July 7th, 2023. On April 10th, respondent reviewed Judge Mada's April 4th order and sent an email message to Owens regarding that order. When respondent asked Owens for information about the Planned Parenthood sonogram, she provided him with her username and password for her Planned Parenthood patient portal. On April 15th, at 1:55 p.m., respondent logged into Owens' Planned Parenthood patient portal. When respondent logged into Owens' Planned Parenthood patient portal on April 15th, records reflected that Owens had scheduled an appointment at Planned Parenthood in California under her real name, apparently in late June 2023. Owens' Planned Parenthood patient portal also reflected an appointment scheduled for July 2nd at a Planned Parenthood location in Costa Mesa, California. Owens' Planned Parenthood portal did not reflect an appointment at a Planned Parenthood location in Los Angeles.
Maybe she's just really bad at geography. Like her MapQuest got all mixed up. Her GPS was all just, terribly out of. She put the GPS on Mo level, and I took her to the wrong place.
And thank you to Dawn. I'm not an a-hole, I'm a biatch. Vet your crap, David. Yeah. And thank you for your $2, getting us $13 towards a spin on the Wheel of Regrets. And for you who just joined, this is the Wheel of Regrets. Every $50, I spin the wheel, and I eat something nasty or drink something I don't want to. It's all for entertainment, baby. Because I don't want to do this sober.
Fair point.
Although respondent had checked Owens' Planned Parenthood portal on April 15th and knew it did not have records reflecting that Owens attended an appointment or had an ultrasound performed at the Mission Viejo location, he never took any steps to correct Owens' false deposition or June 10th hearing testimony that her ultrasound was performed in Mission Viejo or additionally in the case of the hearing Los Angeles. At some point in time, respondent became aware that Eckert's counsel had unsuccessfully sought copies of medical records pertaining to Owens from Planned Parenthood in Mission Viejo, California. Upon learning that Eckert's counsel had not obtained records from Planned Parenthood in Mission Viejo, respondent was on notice that he needed to be more diligent and more closely scrutinize what Owens had told him. Respondent was aware that Eckert had alleged in his motion to compel that he, Eckert, or his counsel had received confirmation from nearly all providers that Owens was never a patient of theirs. You?
All right, let's see. That motion to compel placed respondent on notice that he needed to be diligent in A, ensuring that Owens was truthful about her health, alleged pregnancy, medical records, and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and Eckert was the father. Respondent learned prior to the June 10th, 2024 hearing that Owens had not gone to a Planned Parenthood office in Mission Viejo, California. Prior to the June 10th, 2024 hearing, Owens told respondent that she had to make appointments with Planned Parenthood in Southern California on 2 consecutive weekends, June 23rd to 25th, 2023, and June 30th to July 2nd, 2023. That's not how OB appointments work.
No.
Owens admitted to respondent that she had altered the sonogram prior to the date she hired him. On April 15th, 2024, respondent sent a draft affidavit to Owen to review and sign, after which she informed him by email about some possible changes, including the following, quote, maybe don't include the ultrasound since I tampered with the top and I don't want Dr. Mitchell Owens, expert witness, to question me and my credibility based on that, end quote. On April 16th, 2024, respondent discussed with Owens the draft affidavit he'd sent to her on April 15th, 2024.
Later on April 16th, 2024, Owens executed the affidavit that respondent has drafted, which was attached to the April 26th response to respondent Ecker's amended motion for relief based on fraud. Owens' affidavit, a portion of which is set forth in Exhibit E to this complaint, included an image of the altered sonogram.
She should have added horns or a smiley face. I would have at this point. Go full force. Go.
Oh yeah, this is just text. That, yeah, from that affidavit. Okay. Now I have to find where I was again. It was around here. Exhibit E. Included an image of the altered sonogram. Respondent subsequently learned that Owens had allegedly gone to Planned Parenthood in late June 2023, but took no steps to correct that false statement in her April 16th, 2024 affidavit. The sonogram that Owens claimed was from Planned Parenthood, shown above. Well, yeah, includes a real name, even though that sonogram was not a sonogram that resulted from a sonogram that had been performed on Owens. Owens stated in her affidavit, under penalty of perjury, however, that she had not changed anything on the sonogram other than the name of facility and date. During Owens' March 1st deposition, 2024, she testified that she went to Planned Parenthood anonymously and that she later added her name to the sonogram. Respondent read Owens' March 1st deposition transcript on April 8th, 2024. Respondent became aware that Owens had falsely testified during her March 1st, 2024 deposition that she obtained the ultrasound on July 7th, 2023.
Let's see. Owens told respondent that she went to Planned Parenthood anonymously, and then later at the June 10th, 2024 hearing testified she went to Planned Parenthood using a fake name. Based on respondents' review of the transcripts of Owens' March 1st, 2024 deposition, he knew that Owens either A, testified falsely at her deposition stating she'd gone to Planned Parenthood anonymously and subsequently changed the name of the facility and added her name to the sonogram, but did not change the date on it, or B, signed a false affidavit which he filed and stated she altered only the facility name and date. Now, respondent failed to take steps to address Owens' false testimony during her deposition or address her false affidavit. Respondent never obtained from Owens the original unaltered sonogram that she allegedly obtained from Planned Parenthood in California. Respondent failed to verify with Planned Parenthood whether it treats people anonymously or using fake names. On April 18th, 2024, respondent sent an email message to Owens stating that he had told Eckert's counsel that she went to Planned Parenthood on July 2nd, 2023, but he had located an email message from her to Dr. Simon dated June 28th, 2023, stating that she had gone to Planned Parenthood on the previous weekend. Time is a hard thing to do.
Yeah. On June 3rd, 2024, Corey Keith, the attorney who represented Owens immediately prior to respondent's representation of her, filed a notice in the paternity case captioned as Ethical Rule 3.3 Notice of Candor, hereafter Notice of Candor. In that Notice of Candor, Attorney Keith stated that he told the court the following at a status conference on February 21st, 2024. Owens has not lied in this case. She has not intentionally lied in this to the court.
I feel like he doesn't understand the intentionally. Like Sarah Boone, he's a little confused about what intentionally means.
Yeah. Attorney Keith stated in that notice of candor that at the time he made those statements, he believed them to be true. I mean, he was her attorney for like 2 months. So, Attorney Keith further stated in that notice of candor that based on Owens' March 1st deposition testimony, he no longer believed the statements he made on February 21st were true. Yeah, he kind of changed his mind quite fast. Attorney Keith summarized Owens' deposition testimony in that notice of candor. Attorney Keith included evidence in that notice of candor establishing that Owens had testified falsely before Maricopa County Superior Court Commissioner Cynthia Galketsis several months earlier in Eckert v. Owens, number CV blah 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 blah, an injunction against harassment proceeding. Respondent failed to take steps to address Owens' false statements to Judge Galketsis during the November 2nd, 2023 hearing on the petition for injunction against harassment.
Let's see. Attorney Keith also noted in the notice of candor that Owens testified before Judge G, among other things, that she had seen Dr. Higley, quote unquote, last Friday, 14 minutes and 40 seconds into the hearing, but stated during her March 1st, 2024 deposition that she'd had an appointment with Dr. Higley, but did not attend that appointment. At some point in time prior to the June 10th, 2024 hearing, Owens admitted to respondent that she had incorrectly testified before Judge G that she had just been seen by Dr. Higley, quote unquote, last Friday, but in reality had only made an appointment to see him. She pledged to see him. I say we take the Amber Heard. She pledged.
Yeah, she pledged, because pledging and actually doing, you can apparently use intermittently.
Yes.
Although respondent was aware of the content of the notice of candor, he failed to diligently investigate and research Owens' statements to him, which he presented to the court. Prior to June 10th, respondent reviewed A, transcripts and video recordings of prior hearings, B, Owens and Eckert's deposition transcripts taken before Owens hired respondent, C, the file maintained by Owens' second attorney, including documents he had prepared and filed, D, the report prepared by Eckert's expert witness.
Nick, we're going to need a separate addendum by the end of these for all of her former attorneys. There's just going to be like a Silmarillion of her former attorneys. There's going to be The Hobbit, and then the Lord of the Rings trilogy, and then the Silmarillion. Like, there's deep lore in this case.
Well, here we have all of the victims of LauraOwens.com. So you have all of the.
Oh, that is great, because I was actually going to ask for your recommendation where to find documents and start covering this, because I know we need to get up. Well, I need to get up to speed. You are up to speed.
This is just the Laura Owens criminal case. Here's the Clayton Eckert case.
Oh, wow.
Yeah.
This is so ridiculous. And it's so sad because it's not just Clayton, and there have been people before him that didn't get, the attention. So I'm glad that we are finally bringing this forward, because it's just, it's horrifying as a boy mom to know that there's women out there that I don't want to think about my sons maybe having mouth hugs, but that there would be a similar crazy woman attaching to them like a barnacle.
Yeah, so here you have her parents' bankruptcy, who is now dismissed because they refuse to file the correct documents. And here's Laura Owens' bankruptcy, where she is perhaps with all the shit she pulled there, she's about to get federal charges. And here
yeah,
is
you would.
yeah.
I mean,
And here
with
is
the
the
different
Hayrock case.
localities,
Yeah.
can't she just be called a menace to courts?
Vexatious litigant, or whatever it's called. She's a bad litigant. She should be declared that in Arizona by now because it's absolutely ridiculous.
Well, but the problem is that it's just in Arizona. She can move localities and do this
Yeah.
to another person.
Yeah. Thank you, Henrietta. Vexatious litigant. Thank you. I love my chat because
I know.
if
I love
I
this
say
collective.
something incorrectly, boom, there it is. Folks, I don't mind.
Yes, we love
I
it.
really don't. Yeah, it's amazing to be corrected because thank you.
Yeah, yeah. We are not David Gingras. We know there is plenty of stuff we don't know, and we
Yeah.
appreciate when you help us out.
Yeah. So if I ever say something, hey, that was wrong, and you discover it on a replay crew, say it in the comments. I read all comments. Now, where were we? The report prepared by Eckes expert witness. E. Disclosures made by Eckes counsel. F. The medical records provided by Owens. And G. Possibly other records and information related to issues in the paternity case and related cases.
Based on information that respondent acquired during his representation of Owens, he was aware that Owens had A. testified falsely before Judge G, B. made false statements during her deposition, C. altered a sonogram, which he offered into evidence during the June 10th, 2024 hearing, and or D. signed an affidavit that included false information which was filed with the court. Respondent knew that Owens had not been truthful about the facts material. Let's see, to the paternity case, but did not withdraw from the case or take sufficient steps to address Owens' false statements and altered sonogram. During that June 10th, 2024 hearing, Owens testified on direct examination. She obtained a sonogram at Planned Parenthood in quote-unquote California. I love how California is theoretical. The construct that is California.
Yeah.
Owens testified on direct examination that she went to Planned Parenthood, quote, under a fake name. I want to hump a lot. I want a man. I can't keep a man.
Yeah.
Trap a man.
Mm-hmm.
Admiral Akbar.
Miss Chlamydia.
Which was contrary to her deposition testimony that she went anonymously. Respondent asked Owens on direct examination if she, quote, changed the name at the top of the sonogram. Owens responded, quote, of the location, yes. Owens testified on direct examination that Planned Parenthood sonogram was obtained at the end of June 2023. Now, Owens admitted during cross-examination that she had stated during her deposition that the ultrasound had been performed in Mission Viejo on July 7th, 2023.
Owens also testified to, folks, I have to admit, I have an alcohol problem. I am out of beer. that is a true problem. But I have here Indian tonic, and I'm
gonna have to get some cock and bull ginger beer this weekend for the Corey Richens case, because I actually like Moscow mules. So
yeah, and I have Japanese gin over here. Ooh. Not on the wheel of regrets. And let me pour myself a gin and tonic. And that way. And I put it in a small glass. Hey. Cheers, because we are just $13 towards the spin on Wheel of Regrets, folks. folks.
Yeah,
Buck each.
if David G can do this boozed up, we need to be boozed up. We have to method
Yeah.
act.
Yeah.
How are we
And
going to
folks,
get in the mind of Ginger Ass without it?
and remember, folks, Laura Owens and her mother made $83,000 of their podcast. Me and Mo, half each.
Yeah, I mean, considering I am the kindest cult leader you will ever meet, I mean, I don't wanna sleep with your wife, and I will accept 10% tithe. Gross or net is accepted. I
Yeah.
am like the coolest religion ever.
And folks, as both of us say, always appreciated, never
Yes.
necessary.
Absolutely
If
never
you
necessary.
if you have to check if you can afford it, don't.
No.
Don't.
No.
This is for the people who goes 3 times a day to Starbucks. Give us one of them.
Yeah,
Okay?
and liking and sharing, telling people about it if you think they'd be into this is just, if not, better. So,
Yeah. Watch our videos. Watch our short
Yeah.
form content. Because both of us needs the views and to make it through the glass ceiling that is the YouTube algo. So if
yes, you
can't,
need to pay so that Nick can move close to me. I can be his official co-host and we can hire an editor or
Yeah.
or severely underpay a high school kid who wants to learn how to be a YouTube editor. Send your applications in to mowinthedeepend@gmail.com.
Oh, just so you know. All right.
Is it me or you? I can't remember. We get sidetracked and
I think it's me.
okay.
Owens also testified during cross-examination that she had been staying in Mission Viejo during or about late June or early July 2023. Owens further testified during cross-examination that she had changed the date on the sonogram from July 2nd to July 7th, and that the July 2nd was the correct date. That testimony conflicted with her deposition testimony, when she stated she had not changed the date on the Planned Parenthood sonogram. If you're going to lie, remember you'll write them down and then send those notes into opposing counsel. I'm not giving legal advice here. I'm just hoping that Laura Owens goes, "Oh, really?" Post.
I almost think that Laura Owens, Corey Richins is Laura Owens controlled. If Laura Owens had a modicum of self-control, she would be Corey Richins.
Yeah.
Corey Richins was just more calculated in who she used and more strategic. Laura Owens is kind of like a sawed-off, long gun.
I mean, you have but what connects these names, except one of them, is a few. Let's say you have Laura Owens, you have Corey Richins, Jodi Arias, Sarah Boone, and who else am I thinking of?
Well, you have Letitia Stalk. You have
you have these histrionic women. Alice Evans is also a good example. Thank you. Who simply are that they use the court system to try to use the court system to violate people they think have wronged them. Lori Wallow, Never
and
forget
it would
Amber
almost you would almost feel bad. I mean, if she hadn't victimized so many people, if she had gotten help, it must be incredibly empty to live a life where you can't create a connection with another human without basically, blackmailing them into being around you. I can't imagine how that would be to function or to have never had to, understand that this is not the way anyone, accepts love.
Yeah. And these 4, 5, 6 women are detrimental towards all the women who are actually abused. But
And it's
they have
terrifying.
done more damage to the Me Too movement than any man ever could.
Well, and it's terrifying, a mom of boys, because, there's certain things that you worry about with girls, but now I have to worry about with my boys. Like, hey, if you don't know a girl very well, don't be alone with her. Like, these are
Yeah.
things that I didn't think I'd have to talk to my boys about. If you feel weird about someone, don't be alone with them. Try
Yeah.
to it, and it's also upsetting that had she been a man doing this to women, this behavior would have been caught and criminalized much
Yeah.
sooner.
Yeah. Yeah.
And you would think in the post Johnny Depp, where we're, finally starting to open up and try to destigmatize, male abuse or male domestic violence, you would think that this would be something that we really start taking care of to lend validity to the real victims of DV out there, regardless of gender.
Where were we? When she stated, blah, 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 and the testimony during direct examination that the ultrasound was conducted in late June 2023. During cross-examination, Eckert's counsel reminded Owens that during direct examination by respondent, she testified that she went to Planned Parenthood under a fake name. During cross-examination, Eckert's counsel informed Owens that the Planned Parenthood office for Orange and San Bernardino counties had submitted a letter noting that she had scheduled an appointment for July 2nd, but that the appointment was cancelled, and that the ultrasound image she relied upon, which she claimed to have obtained from Planned Parenthood in Mission Viejo, was not consistent with ultrasound images from the Planned Parenthood offices in Orange and San Bernardino counties.
Yeah, and I honestly wouldn't think that Planned Parenthood would do that with the consideration that they are federally funded.
Yeah.
While I understand that they would probably have some pseudonym protection for possibly DV or other assault victims,
Yeah.
I wouldn't think that they would be allowed to take pseudonyms just because they take government funding. So
Yeah.
you would need to be in theory, if the government were helpful
they will protect your identity with everything they got, but they will not accept fake or anonymous.
Yeah. Let's see. Thereafter, during cross-examination, Owens testified for the first time that her appointment was actually at the Planned Parenthood in Los Angeles. When asked during cross-examination when she went to Planned Parenthood in Los Angeles, Owens stated, quote, exactly when I said I did. Like July 2nd, like it was February. That testimony conflicted with her deposition testimony, which stated that she had not changed the July 7th, 2023 date on the Planned Parenthood sonogram, and her testimony during direct examination that the ultrasound was conducted at the end of June 2023. She didn't write notes. I mean, if you're not smart enough to remember your own story, write notes, like have Post-its. Hell, Letitia Stalk went in with a note. Sarah Boone went in with a damn notebook, and so did Letitia Stalk. Now, it didn't help either of them, but I mean, at least they tried. Let's see. There was testimony presented during June 10th, 2024 hearing that Planned Parenthood requires patients to provide identification and does not allow anyone to obtain services anonymously. Respondent did not take any steps during the direct or redirect examination to address Owens' false or inconsistent testimony, e.g., the discrepancy between the date she testified to, first during direct examination for the ultrasound, the end of June 2023, to the date she stated during cross-examination of July 2nd to the 7th of 2023, and then the date that she testified during her deposition, July 7th, 2023.
Yeah. Now, when this happens, that if you're watching a lot of trials and you suddenly see during cross-examination the essential witness, all of a sudden they get caught in something really bad. The attorney will stand up and say, Your Honor, we request a short break. And that is because the attorney is absolutely livid that this fucking witness lied to you, did not provide the information to you, or provided false information to you that made you look like a complete doofus in front of the court, who that attorney put his, more or less, his law license at stake for the witness or the victim, or alleged victim, or alleged perpetrator, whatever's. So, yeah, or sometimes followed by meeting in chambers, telling the jury you're off for today, if this is a jury trial, or if it's in a hearing. We will meet at a later date. Can I expect your letter of I'm fucking off from this case? Yes, you can, Your Honor. But Gingras just sat there.
Let's see here. Good Lord. Violations related to responders' pursuit of meritless claims, false information in an affidavit, and presentation of Owens' false testimony / changing versions of events. Based on conduct set up forth above, respondent violated ER 1.3 by failing to act with reasonable diligence in representing Owens, ER 3.1 by asserting or controverting issues when he did not have good faith basis in law and fact for doing so that was not frivolous, ER 3.3 subsection A and B, by knowingly failing to take reasonable remedial measures when he knew that Owens intended to engage in, was engaging in, or had engaged in criminal or fraudulent conduct related to paternity case. ER 3.4 subsection C, by knowingly disobeying an obligation under rules of the court. ER 8.4 subsection C, by engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. ER 8.4 D, by engaging in conduct prejudicial to the administration of justice. And Rule 54C, Arizona R Superior Court, by knowingly violating any rule or order of the court. They should have just said all the rules. Like, it would have been shorter just to say he didn't violate, like, peeing outside.
He didn't violate half of the rules. Non-meritorious appeal. All allegations set forth above are incorporated herein as if set forth in full. On September 5th, 2024, respondent filed a notice of appeal regarding the order regarding application for attorney's fees and costs, Owens v. Eckert, Arizona Court of Appeals. On September 9th, respondent filed an amended notice of appeal on Owens' behalf. On November 14th, respondent filed an opening brief with Division 2 of the Arizona Court of Appeals, which included non-meritorious arguments. A, respondent falsely asserted that Judge Mada ordered sanctions under Rule 26B. Respondent set forth scenarios that were not based on the fact, so they did not have any bearing on the propriety of the fees awarded. Respondent failed to meaningfully challenge Judge Mada's findings of fact. And D, respondent's position on appeal was unreasonable, in part because his Rule 26 argument was not grounded in law or fact, and his assertion that Judge Mada was biased and committed structural error failed to meaningfully address her rulings and ignored applicable law. On March 28th, 2025, Division 2 of the Arizona Court of Appeals issued a memorandum decision denying Owens' appeal. The Court of Appeals memorandum decision stated, in part, we note that a significant portion of Owens' appellate arguments relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded attorneys' fees and costs under Rs. Paragraphs 25.324 and Rs. Paragraph 25.415. None of these scenarios posited posited by Owens have any bearing on the propriety of the fees awarded in this case, as that determination must be based not on conjecture, but on what actually occurred. The Superior Court also concluded that paragraph 25, 324b applied because Owens had, quote, provided false testimony as to the viability of the pregnancy, end quote, and hence sent Eckert a letter prior to a deposition that indicated her intention to sue him for $1.4 million in collateral allegation unless he agreed to dismiss this action that she initiated. Yeah, she is threatened to sue him for $1.4 million.
Stop or I get it.
Yeah. Have you seen Blazing Saddles?
Yes, I have. Yes, I have.
I can't repeat what was said in that scene.
No,
for
but I
obvious
love
reasons.
that.
Yeah, it's amazing.
What would those reasons be?
On appeal, Owens does not meaningfully challenge these Superior Court findings, but instead argues 25.324 does not apply in paternity cases. Section 25.415a3 states, quote, the court shall sanction a litigant for costs and reasonable attorney's fees incurred by an adverse party if the court finds that the litigant violated a court order compelling disclosure or discovery. Here, the court made such finding. Thus, it was required to sanction Owens for the costs and reasonable attorney fees Eckert had incurred. Owens does not meaningfully challenge that finding. And then just, yeah, two exceptions, blah, blah, blah. Owens' position on appeal is unreasonable. See McGee.
Haven't all of her sexual propositions been unreasonable?
Yeah.
If not improbable?
I almost said see Magoo, but not. 206 Arizona 589 and 1. Her Rule 26 argument is not grounded in law or fact. Likewise, her assertion that the trial judge was biased and committed structural errors does not meaningfully address the trial court's rulings below and also ignores the applicable jurisprudence. We therefore award Eckert his reasonable attorney's fees and costs on appeal. Some brackets in original. Your turn.
Okay, violations related to non-meritorious appeal. By engaging in conduct set forth above, respondent violated ER 1.3 by failing to act with reasonable diligence in representing Owens. ER 3.1 by asserting or controverting issues on appeal when he did not have good faith basis in law or fact for doing so that was not frivolous. And ER 8.4 subsection D by engaging in conduct prejudicial to the administration of justice.
Criminal confidence says, I just have to comment that I searched YouTube for lottery scratch off live.
Wait a minute,
and this was the fifth recommended video.
I could make a there are a stream of people just scratching off lottery tickets. That is the weirdest thing. And I know that there are hoof-like shaving videos on YouTube.
Which I immediately remove.
Mr. Mo loves them, and I'm like, oh my god, no. Why? Just know all the no.
Have you at one point some time ago, there was infected hoofs.
Yeah, Mr. Mo's like, hey, you want to watch this guy? I was like, no, never in my life. And no. And why does this keep coming up on my feed? It's like this and the pimple popper. Those are like my fear factor. Like if I want to work on, like my squeamishness, I try to watch one of those videos. And if I get through it without doing one of these things, I feel brave.
Folks, I've lived on or around farms for a majority of my life. I've seen it in real life. I do not want to see it on video. It is equally, if not more, disgusting in real life when that happens. Oh, let's scratch the hoof. Oh, an infection, and it just pours out.
Yeah, no thanks. I'm just no good.
I'm fine.
I mean, I'm glad that the aminals have people that will fix that for them because I'm sure it hurts them. But Yeah, no, I gave it up for Lent. All my hoof shaving. It's gonna be a weird sandal season, y'all.
Oh. Oh, look at this.
Oh, wow.
Dated this 25th day of February 2026. State Bar of Arizona, James D. Lee, Craig Hensley, Senior Bar Counsel. Originally filed with the disciplinary clerk of the Office of the Presiding Disciplinary Judge of the Supreme Court of Arizona this 25th day of February 2026. By Melissa Duarte, JDL MD.
Now, would
Yeah.
would are there certain lawyers that represent lawyers in these sort of situations, or do you think he will be arrogant enough to try to represent himself?
He's definitely trying to represent himself. I can't imagine he gets someone to represent him. And folks, this is just the Laura Owens case in Arizona. There should be more. There should be in California as well, because he has tried and tries to represent. Then you have his idiocy regarding the Laura Owens bankruptcy case, where he tries to interfere. But, I mean, they haven't allowed him in yet, so technically he hasn't violated anything yet. I'm just saying there should be, even though this is more than enough for sanctions against him, there should be more.
Yeah, I mean, this at
Mm.
at the point where I mean, I don't think it's normal that you have maybe a 50-page disciplinary note.
No. And I think they didn't even include all the things in the Laura Owens case.
Yeah, and thank you guys for sharing that website, The Victims of Laura Owens, because I have been wanting to get on this case, but having a place to find all of the things in one area makes it so much easier. So whoever did that, awesome work. That's the one really good thing that I have seen come out of this as a person who hasn't been, completely on it the entire time. I am so like kind of like in an Oprah proud mom that this community law tube is shining a light on these and getting, you know, getting attention for victims who might not always get attention all the time, and especially not just Clayton, but the other people who have been living with this for years and years in silence or without a lot of knowledge.
Let's see. I'm just checking if there is something.
Now, how long does
new.
he have to respond?
Usually 30 days. So up until March 25th or March 27th.
Have we checked Twitter to see how he's responded on Twitter? Because I don't think he's going to learn anything, and I'm guessing we're going to have a response real soon, or whenever he finishes vodka, allegedly in Minecraft.
Let's see here. Dun, dun, dun. Did he lock his? No, that's not him. Why can't I find David Gingras anymore? Or is it the Gingras? No. No, I can't say. Oh, what is this? Real estate, romantic and trappings. Oh, that okay. Laura Owens. The theory from some people is that she used this I'm looking for property to find men. Specifically Clayton.
That's
Yeah,
a
I
whole
might be
lot
blocked.
bunny bo I mean, she's already like a DEFCON 4 bunny boiler. The
Mm,
fact that she premeditated
mm.
the Immaculate Contraption twins, I
Yeah.
mean,
Yeah,
man, have you thought of crocheting or cross stitch? Keep your hands busy and, like, you sitting down so you don't hurt people. Macrame has no sharp things.
yeah,
Macrame.
yeah,
Paper
yeah.
mache.
Let's see if Schnitzel Ninja has something new. No. Schnitzel Ninja is the account on YouTube that posts a lot of stuff. Let's see here. The latest is Laura Owens' Adre complaint against Clayton Eckert. She actually reported him towards the house flipping authority. What's it called? Arizona Department of Real Estate. Yeah. So Clayton Eckert does real estate. And so after he told her to fuck off, she reported him for unethical conduct.
Okay, now I don't watch The Bachelor because it's kind of icky, but was he going after a girl or was he the guy everyone was going after? Because I
have no idea. I proudly admit I have never seen any full episode of Bachelor or Bachelorette. Just as I accidentally saw some women around the table saying stupid things, and then I discovered, oh, I'm watching the Kardashians. I'm flipping channel here. And
okay.
yeah.
Thank you guys, chat. Okay, like I said, I've never watched those either. If it's not a true crime or a WW2 documentary, I'm not watching it. So okay, that makes
Yeah.
it's now, didn't she have in theory some sort of vague idea of a business that did something or other? Word salad Kamala Harris. I can't figure out what she did. I know she has a website where she called it like Keys or something. Keys of Delusion. Also, doesn't she have a CD? Oh my God, Nick. Rumble listen party of the Laura Owens country CD.
Oh no. What? Where? On Rumble?
No, I was saying we need to do a Rumble exclusive of the Laura Owens country music CD. We'll have a listening party. We'll have you'll probably need an emetic, syrup of Ipecac available right next to you.
Wait a minute, where is it? Where is it? Oh, let me go to Suno. Because as some of you might have missed, when I found out that Laura Owens had an album confessing her love to dogs, I did song. I did Suno song called Laura Loves All the Doggies. Let's listen to it.
Laura walking down the sidewalk, shouting at the pugs in the mud. Their noses wet, their feet go tap, tap, tap. I marry every wagging tail. Yes, I love all the doggies. Every now furry ghost. She kisses every sloppy face. Kiss the snow. I throw my heart like a tennis ball. Chase it, shoot it, tear it apart. Every bite mark on my silly soul is a present from my happy heart. I love all the doggies. All the doggies. Every nose, every tongue, every bark in the park. I love all the doggies. Oh, let me on my shoes. And I love. Laura whispers in a broken robot voice. I choose you, Beagle Bride. Then she screams for 30 seconds. All the doggies. Tiny teeth, giant hearts, muddy paws on my chest. I love all the doggies. Let them howl, let them jump, let them chew. On my best.
You know, honestly, I don't doubt that her internal monologue sounds exactly like that.
Yeah, but I lost 40 viewers. It's my interpretation of this is not Laura Owens. That is my interpretation of what I saw before me. And I actually asked the chat at the time what type of music, and somebody said Yoko Ono Screamo.
It's a weird genre.
Yeah.
I honestly thought it was Bjork death metal.
And this came out.
They sound oddly, Yoko Ono and Bjork switched at birth.
Yeah, so that was my interpretation of when I saw in that David Gingras that when he tried to talk all the love, look how positive Laura Owens is. And here she made an album where she confesses her love to dogs, and I'm just, I'm going to do something here. And the chat helped, and this was what came out of it.
It's a good one. I have to start my walking pad this coming week, so it's got a good beat. It'll and if I fall asleep, it'll wake me right back up.
Yep.
Because I get up at 4.
All right. Now,
all right, so
we didn't get all the way to. We got $13 away from the Wheel of Regrets, but I'm feeling generous.
Woohoo!
Yay! So I'm going to spin the Wheel of Regrets. But since you didn't pay all the things for it, I'm saying, fuck no. To no to that. No, don't want that. No, don't want that. No, stop it. Stop it. I don't want Canadian whiskey. This wheel is so against me. Now this is better. This is much, much better. Sugar House Bourbon. Where is it? There it is. I bought the Malort. That because the Wheel of Regrets is very, very against me. I had to remove that, and I took on the Canadian whiskey, which is down to this level now. It's disgusting. Meanwhile, the bottle of Sugar House Bourbon, which is actually nice bourbon, still half full. But the
Colorado
wheel,
Canadian,
this fucking wheel of regrets hates me.
I think Nick bought the cheapest Canadian whiskey available to all mankind. I think it was $1.99.
Yeah,
And it's plastic. And the
plastic
cap
bottle.
doesn't even come off because
No.
it assumes you are so drunk that you will not remember where your cap is.
Yeah.
It holds it on. I mean, it's kind of nice if you think about it. It assumes you're a drunk ass.
Oh, let's see here. I don't think I have an. No, I don't have an Arizona. I'll have one of Nick's Bar, Miami. Dun, dun, dun. Oh. Cheers.
Oh.
Ooh. Ooh. All right, folks. That was the bar complaint against
I can't believe
David Gingras.
Has he gotten away with this for years and years? Because this is the amount of hubris that seems to build in when you have gotten away with things for years and years. I mean, this is the kind of entitlement that you generally see in like a kid that's never told no by their gentle parents.
Yeah, if he have, because since this case was high profile, people noticed, people started digging. There might be people out there who he represented, alleged victims or alleged perpetrators, that got a really bad deal because he doesn't care if his client is lying, as long as he can get a win out of it. And it's very hard for someone unexperienced, let's say somebody's pro se, to win against an attorney that is, hey, I'm going to lie my ass off to get a win, or help my client lie to get a win. It's hard to win. It's hard to defend yourself against that. So with the conduct that he has done in this case, he has practice doing this.
Yeah, I mean, it just doesn't seem like it's something that you would. It's like, you start with peeping Tom and then you go up to, stealing clothes off a laundry, thing, and then it escalates further and further. This isn't something that you just decide one day to call out a judge on social media and in a motion to a court. You don't decide to italicize he one day. I mean, unless you're drinking vodka from a silly straw, allegedly.
Sorry, I had to write. Something is wrong on Twitter, and I have to correct it. That.
Oh no.
And no better time when
Yes.
a beer, a gin and tonic, and a shot later than to start writing on social media.
Well, that's
no.
when Twitter is at the importance that it deserves when you're not sober.
Yeah. Now, something that's not in here, because I believe is why Gingras is doing his best to postpone. That is his second DUI, which is not in here because he hasn't been convicted or pled to it yet, but he has postponed it for over a year now, I think. He knows
How is he getting away with this?
he knows how to play the system because he's an attorney. So he asked for extension, he asked for this, he asked for that, just to get, because if the DUI was included in this, it would be a much stronger case. Now, this here, will it, render in him losing his license. That is the most extreme of the sanctions against him. I'm not sure. But I at the moment, I would settle for him being barred from practicing law for 6 months.
Absolutely. I mean, when we went to his slurred typing warning about the judge, I mean, that is beyond the pale. That is something I expect from, a 14-year-old mean girl, with a burn book. I would never in my life think that a professional would do something like that.
Oh, yeah, Gingras law. Yeah.
Ooh.
Let's see here. Let's check what he wrote the latest. And thank you so much, Amanda. He's from March 6th.
That escalated quickly.
Yeah.
I love that he uses emojis because he's, 65.
The weekend is open, so the comments are closed. I don't have time to block, delete all the hate. Go out and have a nice weekend. Touch grass. Fuck you too. Fuck you too.
You're not my supervisor, Dave.
Got guests this weekend, so I'm signing off early. No more videos. Who the fuck wants to spend time with you, that asshole?
Imaginary friends.
Commission on Judicial Conduct Objection to Subpoena. Let's see. Oh! He's
reading for those who care.
firm State Bar. So State Bar, Office of the Attorney General. Okay. In the Supreme Court of the State of Arizona before the presiding disciplinary judge. So he's trying to non-party objection to subpoena duces tecum for Commission on Judicial Conduct in the matter of a member of the State Bar of Arizona. So this is him replying. Okay.
Oh, he wants to quash the subpoena.
Yeah, it's just 7 pages here. Pursuant to Arizona, I have to put it up here instead and make it bigger. Pursuant to Arizona Supreme Court Rule 47H3, the Commission on Judicial Conduct, the Commission, by and through undersigned counsel, hereby respectfully moves the presiding disciplinary judge for an order quashing portions of Respondent Gingras' subpoena. What? Oh, attorneys, this is okay. This is he wants to quash parts of what we just read, or something of the sort. I'm not by and through undersigned counsel here. Undersigned counsel?
Oh, so he does have a.
I'm not entirely sure here.
A little late to keep us from reading all of that.
No, I'm not entirely sure. Let me go back and see.
Copies of all documents related to any and all complaints or report of misconduct involving Judge Julie Ann Mata, respondent judge, sent to commission on. Oh, so he wants to get all of Judge Mata's.
Oh, no, he wants to know who sent all the stuff to Judge Mata.
Oh.
He wants it revealed. He wants names on the people who sent in to the commission to, hey, you need to look at this guy. I think. Okay, let's see here. By through undersigned counsel here, but respectfully moves the presiding disciplinary judge for an order quashing portions of Respondent Gingras' subpoena. So he has subpoenaed all the records of what has been sent into the State Bar about him.
Can I be a fly on the wall when he reads it?
Well, this is from his webpage. He posted this on his webpage.
I mean, when he gets all the complaints and it's all like...
Oh, he already have it because that was posted on February 25th. So he already have that.
Oh.
Yeah. Let me see here. Which one is first? 3.6. This is sent in also 3.6 at the same day. Let's see here. I have to. I'm just checking here for other documents.
No problem.
Okay, February 24th. 26. Owens versus Andreev. Yeah, we know about that. Fee motion application. Yeah, he is motion for costs against Rob, although he presented himself pro bono. That doesn't mean he doesn't have costs, but those are for office stuff. But I don't care about that. Bank fraud. I'm just checking here to see if there is anything before this. Oh, he recorded a video. I don't care, because if I show it, he will try to copyright strike me.
Now, if he does anything with the information that he gets from this, is he allowed to know certain who sent in complaints about him? Are there protections for like anonymous complaints, or he seems like a slimy person allegedly that would use these to
23rd.
retaliate.
Let's see here. February 23rd. Filed February 23rd. Okay, not that. Not that. Come on, read more. No, this is just a Hey Rob thing. Yeah, okay, let's see. I don't know where his subpoena dated February 23rd, 2026, for reasons set forth below. The subpoena was emailed to the Commission on February 25th rather than personally served as set forth Rule 47C2B. Respondent Gingras indicates his cover letter to the Commission is a non-party in this matter. Undersigned counsel affirms that this motion is not made for the purposes of delay and is in the interest of justice. The subpoena. The subpoena seeks all documents related to all complaints or reports of misconduct involving Judge Julianne Mara, Central Commission on Judicial Conduct, CJC, including but not limited to documents relating to CJC. This is his subpoena. All complaints received, meaning all, including names and addresses and email addresses and everything. Documents reflecting on how each complaint was resolved, or correspondence sent to or received from the respondent judge and or her counsel or representative, if any. All documents and records obtained by the CJC from any source in connection with any complaint against Judge Julianne Mara. Yeah, he wants it all. He wants it all. Objections. The Commission, a non-party in this matter, is created by Section 5 of Article 6.1 of the Arizona Constitution, which states the Supreme Court shall make rules providing for confidentiality of proceedings. These rules govern the Commission of Judicial Conduct and are promulgated by the Arizona Supreme Court. CJC Rule 9 governs public access and confidentiality, and what information becomes public is largely driven by the outcome of a complaint. In an effort to eliminate potential confusion, all requests will be addressed herein with the lettering as set forth in the subpoena itself. To the extent that documents can be released, the instruction to retrieve them electronically have been provided to respondent Gingras via email at that email prior to the filing of this objection. The reference commission case 2024-265 arose from one complainant, responded Gingras. All complaints received. Mr. Gingras was the only complainant in commission case and can be provided with an unredacted copy of the complaint and supplemental materials he filed. Judge Matta has no public discipline with the commission. All of Judge Matta's dismissed complaints filed by other individuals, to the extent there are any, would be confidential pursuant to CJC Rule 9A1. Documents reflecting how each complaint was resolved. The Commission can provide Mr. Gingras with an unredacted copy of the dispositional order in the Commission case number 24265. These are the same documents previously mailed to him February 12th, 2025. Complainants, as defined by the CJC rules, are entitled to written notice of the disposition of their own complaint pursuant to CJC Rule 10. Any dispositional orders on other complaints filed against Judge Matta, to the extent there are any, by other complainants, are confidential pursuant to CJC Rule 9A. So he's seeking who else. So this is not the case against him. This is, have anybody else complained about Judge Matta, it seems.
Oh, that's what I was kind of wondering, if he was trying to get the complaints that were made about him, or if
I
any
thought
had
so
been
when
made
I
about Judge Matta.
Yeah,
He-
I thought
he
so
is
when I
so
read the
slippery.
initial things, but no, this is him seeking information if more people have complained about Judge Matta. All correspondence sent to received from the respondent judge and or her counsel or representative, if any. Judge Matta's response in commission case is confidential under CJC. The commission may discretionary may disclose the judge's response to a complainant pursuant CJC Rule 9C1. Mr. Gingras made that request February 10th, 2025, and it was denied by order dated April 2nd, 2025. To the extent Mr. Gingras may, by seeking Judge Matta's response to any other complaints that he did not file, those are confidential. All documents and records obtained by the Commission from any source in connection with any complaint against Matta, they are confidential pursuant to Rule 9b. Copies, confidential. Confidential. Complaints, to the extent they exist, are confidential. Conclusion. For the reasons provided above, the Commission objects to the production of additional records beyond what has been provided and asks that this court quash the remainder of the subpoena. Respondent Gingras has been asked to withdraw the remainder of his subpoena as to the Commission, but has indicated that he will not do so, to nobody's fucking surprise. To the extent this court is considering compelling the release of such documents, the Commission asks this court conduct an in-camera review to determine if the relevance of the documents demands release in light of the existing CJC rules, and that any release be pursuant to a protective order. But we know he doesn't care about that. Further, it is requested that before any future subpoenas or requests for depositions are granted, to the extent any are made, the Commission, a non-party, be heard. This will help alleviate an unnecessary use of public resources going forward. Respectfully submitted, 5th day of March. And then you have his... let's see, so I have the correct one. The escalated quickly. Gingras' motion to compel. So this is Gingras' motion. In a matter of a member, motion to compel responds to motion to quash, which is sent in the same fucking day. Pursuant to Supreme Court Rule 47H and Arizona blah blah blah, Respondent David Gingras, responded, or Gingras, respectfully moves the PDJ presiding disciplinary judge, okay? For an order compelling a non-party witness, the Commission on Judicial Conduct, CJC, to comply with subpoena duces to come, attached hereto as Exhibit A. This motion may also be deemed as a response to the CJC's motion to quash, which also seeks a protective order. As explained below, the challenge subpoena seeks information which is plainly relevant and is either admissible or reasonably calculated to lead to the discovery of admissible evidence. The information is therefore properly within the scope of discovery under Rule 26b. The information is not privileged, nor is it protected by any valid legal or statutory authority that would allow the CJC to withhold it, except they Commission Rule 9b, confidentiality. You, Mr. Gingras, has to argue while your rules that you cite are superior to Commission Rule 9b. And it seems like, no, it's not privileged at all. That's his argument. Nor is it protected by any valid, listen to the word, valid legal. So he just doesn't cite anything. He just tries to disqualify the commission's citing. That's no, you fuck twat. That's not how this is done. Seriously, this is so he doesn't cite any fucking thing. Oh, well, he might do later. But the last time I checked his citings, I found something that didn't exist and something that was not published, which you can make a judicial note. Please take a judicial notice of it, but you can't cite it as case law, which he tried to do because he's a fucking moron.
He just. I would never, I guess I wouldn't even have the arrogance to tell the court to basically go screw themselves. Like, we've asked you to remove this. It's stupid. It doesn't make sense. You are irritating us. And he's like, nah.
He is basically telling the commission that I don't care about what they cite. I don't see them as valid legal or statutory authority. Who the fuck cares what you think?
Yeah.
Put it in fucking writing, you retard. Accordingly, the PDJ should grant the instant motion and order the CJC to immediately and fully comply with the subpoena. The PDJ should further deny the CJC's request for a protective order, as no good cause for such an order has been shown. Please let there be citations. Introduction. This case is exceptionally complicated. No, it isn't. You allowed your client to lie in court. That's the basis of it. But in the interest of expediency, this motion will not delve into the entire story. Of course not, because you will be fucked. Nor will this motion address any matters other than those essential to the pending motions. In short, among other things, the State Bar has charged respondent with making false and inappropriate statement about the judge. Yeah?
Yeah?
The substance of the... Yeah, I mean... For fuck's sake. Every damn time I'm reading one of his texts, it immediately picks on my nerves because I know how to write properly. And this fucking moron who's barely conscious just puts in words because he feels entitled to things.
Yeah, it's and it's such a condescending way of speaking. Like, well, they assume, and I get that they're purporting that these things are true, but they're also the disciplinary commission. They're looking at court records. It's not like they're looking at YouTube. It's not like they're looking at Nick's channel. They're taking from transcripts. They have exhibits of your dumb ass.
Yeah.
From your motion.
And you are supposed to send it now. Now he has. Now this is the things that he sent in after this, what we read before, February 25th. He has had this, and he chooses to do this. Instead of working on a reply, please don't take away my bar card. Please, please, please. Grovel, grovel, grovel. He's digging an even deeper hole. The substance of those statements is set forth page 100 to 108 of the amended complaint filed in this matter, and certain exhibits to the complaint. Yeah. The bar alleges respondent made false statements accusing Judge Maddow of several acts of misconduct. Those acts include violating the Code of Judicial Conduct by engaging in ex parte discussions with her father, a man named Harry Howe, about a pending case she was handling, the Owens v. Eckert matter, cited extensively throughout the complaint. A separate... here's the thing. What you put in your paper only contains what you thought happened. There's not a shred of evidence that this actually happened that was presented. You just put it in a fucking motion as if it was true, but it was all in your sick, demented, mad cow disease riddled brain. You absolute
He's like a... It's just, again, I work with, or I don't work with, but I hang out with lawyers that take pride and, care about ethics, work really hard to dispel the slimy, stereotype of lawyers. And he just fulfills every single stereotype, and he can't even be smart. Like, be an evil genius, be Lex Luthor, don't be freaking Beavis and Butthead.
Yes, every time I read something he writes, it's pissing me off because it's so obviously bad. It's so obviously poorly written. And then he doesn't cite. And then he makes shit up. And it pisses me off after working for close to 35 years within law. I know that had I done something remotely close to this, I would not have a job. And here, this asshole is making a career out of being an asshole. Let's get through this. See complaint, page 102. A separate statement accused Judge Maddow of violating the Code of Judicial Conduct by conducting independent research into the facts of Owens v. Eckert, and by making a factual finding based solely on a social media post published on the internet after the evidentiary hearing was completed in Owens v. Eckert. See page 106, incorporating Exhibit D to the complaint, which contains those statements. Let's see, which was that? Hold on here. You know what Exhibit D was? His blog post. The public warning. Judge Yulimada. That is what he's referencing here. You absolute tool. Although the bar's complaint does not explain this detail upon learning of evidence which appear to show Judge Madow's misconduct, it's all in your fucking imagination after you read it on what was the fucking page? TheRobingroom.com, where an unidentified author claims Judge Maddow took his children away based on bogus information the judge found in a Google search. What you need to do, you cunt, you fucktrat, you absolute retard, find the case. Cite that very case. And you don't, because it's not there.
Well,
You
is
never asked for it.
he's self-authenticating the actual evidence of
Yeah.
his crime. He's
Yeah.
citing his crime.
He's citing his own blog post where he does not actually reference the case where this allegation was put forth.
I mean,
It's
Nick,
mind-blowingly stupid.
has he thought about hiring Daryl Brooks as his third-party intervener? Because I never thought I'd say this, but I think Daryl might do better.
He needs a non-lethal dose of what Corey Richard didn't give her husband.
He needs a little hush puppy action. A allegedly in Minecraft.
Although the boss complaint does not explain this detail upon learning of evidence which appear to show your... That's not evidence! That is you putting something on your fucking blog.
Nick, if he
Where
puts it
you
on the internet, then it's real. Duh. Haven't you seen Snopes?
Even Mr. Gingras took off. No, I'm not in here anymore. Nick is too mad. Respondent filed a complaint to Judge Mara with the CJC. A copy of the CJC complaint, excluding the substantial supporting evidence provided to the CJC, is attached as Exhibit B. How many? 25 fucking pages. The complaint respondent filed against Judge Mara with the CJC contains many of the same statements identified in the complaint filed by the bar in this case. Specifically, the CJC complaint alleged there is clear and irrefutable proof showing that Judge Mara conducted an independent investigation into the facts of the Owens v. Eckert case, and following a bench trial on June 10th, she issued a ruling in which some of her factual findings were not based on any evidence admitted at trial. I don't remember reading this.
Because he wrote it. This is a complaint.
Yeah. The CJC complaint alleged that he...
No.
So he's using his... what the fuck?
He's alleging that she did independent investigation based upon his own complaint that he wrote. Because let's be real, no one else wrote on behalf of him.
Yeah.
Although, doesn't she have fans?
Yeah, blah, 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 blah. But this is what you claimed. But
it is.
Here's
It's
the thing.
respondent's complaint.
Yeah, this is what you alleged against Judge Mara. Then you have 100% of the burden of proof. And instead you try to turn around, well, they didn't investigate if what the shit I spewed was true. For the love of fuck.
He is annoying.
Yeah. Again, respondent's complaint to the CJC regarding Judge Mara was filed on July 9th. A short time later, Judge Mara unlawfully retaliated against respondent in several ways. One, by denying a notice of change of judge. No, because you were a retard and she denied it, which she was in full right to do. Which, by rule, Judge Mara was prohibited from deciding. By filing a complaint against respondent with the state bar, which respondent alleges to be frivolous. This is so
50 pages of frivolous.
Those acts were also reported to the CJC by respondent. Didn't you say up here that you were more or less, in the interest of expediency, this motion will not delve into the entire story, and you just pour manure, bad, rotten manure onto paper? Yeah, folks, I don't want to read this.
No,
I was in a good mood. Let's just let's. I can't. I can't.
Nick's losing the will to live. We will have to limit our Laura Owens to under 4 hours.
But this is the tactic he uses against people. Now, had he been against me, I don't care. I'm salaried. I can spend all the times in the world.
Oh my God, Nick, we need to make Ass Wand merch.
Ass Wand.
We trademark it. I'm just saying.
I have ideas.
Unassigned or assigned co-conspirator.
Ass one gned Co-conspirator. Yeah, that's it.
Yes. And it says ass, which is why I like it.
Yeah, ass is always funny.
And
Ass
it
is
hurts someone dumb's feelings,
Yeah.
which I like.
Yeah. No, in my 35 years, have I met attorneys like David Gingras? Yes. Rarely, because rarely have I met someone who think this is a good tactics. Because I'm salaried. I don't care. Now, the people that have presented those assholes to me, they have to pay them to try to waste my time. I'm salaried. Fuck Todd, I'm salaried. I can spend forever on this while the company can go bankrupt because they're paying you loads of money. I don't care. You send in stuff, I will reply. You send in weird stuff, I will simply reply. I can go on forever because I'm salaried. Now, contrary to what I do at work on a daily basis, this is wasting my time.
Yes.
Because it's pissing me off. That's not good content.
No.
Yeah.
But let's see, Nick, we've got Corey Richens. Maybe we should set up Saturday like you guys did with Jodi Arias, and we can catch up on Laura Owens, because maybe there are some people that haven't kind of gone for the beginning. And
because the closer we come to the criminal case, people might want, how did all of this start?
Yeah.
And we can do a compressed versions of the literal. I mean, there are people out there who have hundreds of videos and stream, which are really hard to, if you're new to this and interested in knowing how did all of this start. So maybe we can do something like that on Saturdays in the Slightly Bust. Yeah, and use that as Slightly Bust.
I'm down with.
Yeah.
Look, if I have to read more shite from this arse, I'm going to need.
Oh,
and David, it's Mo, M-O. There's no E in it.
Yes, J.K. Debug. Mo and Nick will give us the blow-by-blow of the Laura Owens saga.
And no one gets pregnant. And no one's knocked up.
Nope. Nobody gets pregnant. No. First of all, we are in different parts of the world. And I will not say anything about size and accuracy, but yeah.
Well, I mean, according to Laura Owens' doctor, so you're saying there's a chance. The jet stream exists, Nick.
Yeah. But, I mean, I think Schnitzel Ninja has all the hearings from the very start that are published. So every Saturday we can go through. I mean, some of them are like a couple of hours long, but some of them are like 30 minutes. So let's do a series.
Yes.
The Slightly Bust series on Laura Owens from the beginning. Yeah.
A night to not remember.
A night to not remember. And yeah, I will not even finish reading his garbage because it's a waste of time. It's a 403. It's a complete waste of time. Or 404 or whatever it is.
Yeah.
Yeah.
And thank you guys so much for hanging out with us. Let's see. This week we start back on Corey Richens. Now we start a little early. Obviously not Monday because we're all caught up. But we do generally like to start a little early with a recap of the afternoon. So hang out with us. We start at 9. So not Monday. We'll start at normal time. But let's see where the state's going to end up, because they did give us a outline of either Monday evening or early Tuesday morning that they would be resting. Now, I don't see the defense taking 2 weeks.
No. I mean, at the very best case scenario, they will have somebody to talk about how people can handle grief. they will have somebody who will refute the fentanyl alcohol, saying he had to have taken it after 10 p.m. when Laura Owens, according to her phone, apparently was downstairs.
What's her face? Corey Richins.
Yeah, Corey Richards.
It's so hard to keep all these cray women.
Yeah.
And
Corey
if
Richards.
you guys need a spot to wake up in the morning with headlines that you need, none of the politics you don't, true crime you crave, and the absurd that I find on the internet, I do Mornings with Mo. So it's like an hour-long news stream, 8 a.m. weekdays. So it's about an hour, and we have a lot of fun. And then I head you guys out to trials.
Yeah. Now, in about 10 minutes, that attorney, the annoyingly neutral attorney, is having a live stream.
Oh my goodness. Yeah, I saw that. He is amazing. I want to talk to him.
Yeah, what's his channel name now again?
I don't know. I call him the annoyingly neutral lawyer, which is terrible because that's not his name.
Yeah, I have to.
JKD Buck, help us. We're not smart to remember stuff.
JKD Buck, help us. What's his name?
Honestly, legitimately, Nick, yours is about the only real name I know because I'm so terrible with names.
Because I want to put his link in the chat.
He really is he's quite good, and he has such a calming voice.
Yeah.
And he really does make good points, and I think he calls polls and strikes well because he's talked about the state and the defense.
Yeah. Let's see here. Maybe somebody posted it to me.
JKD Buck put the live stream up.
Yay! Yeah, follow his live stream because I can't redirect to him.
JD
a lawyer explains. JD, a lawyer explains. Yeah. So he's and tell him hi from me. And well, not in that manner.
Mo?
And Mo. And ask him, hey, contact Nick or Mo because they want you as a guest. Nothing like peer pressure to get somebody on the show. Folks, thank you again. Thank you to let's see here. Thank you to Rosalind Duke, to Lisa, to Marielle, to Salty Sea, Jinx, Dawn, Welsh Lady Reads, and Amanda. Thank you so much for your monetary support of this channel. It is worth a lot. I promise you, it is worth a lot.
Yeah, thank you guys so much. This is so much fun to, kind of, like I said, when I was on with you and Nick yesterday, Mr. Mo has never been so happy. I've found my tribe to talk about all the, my nerdy stuff.
Yeah. Now, Suno makes 2 versions of each song. So you heard one version of Laura Loves Doggies. I haven't actually listened to the second one. So I'm going to send you off with that version. So, thank you again. And see ya. No, not that one. Where is it, that one?
Listening into smoke, cottage falling like small surrendered balls. Dead into wake. they do. Laura walking down the sidewalk, shouting at the pugs and the mutts. Their nose is wet, their feet go tap, tap, tap. I marry every wedding tale, and every yes I do. I love all the doggies, all the doggies. Every nose, every tongue, every bark in the park. I love all the doggies. Even when they pee on my shoes in the dark. Laura rolling in the dog hair, covered like a furry ghost. She kisses every sloppy face. Kiss the snow. I throw my heart like a tennis ball. Chase it, chew it, tear it apart. Every bite mark on my silly soul. It is a present from my happy heart. I love all the doggies. All the doggies. Every nose, every tongue, every bark in the park. I love all the doggies. Even when they pee on my shoes in the dark. Laura whispers in the broken robot voice, I choose you. Be the bride. Then she screams for 30 seconds. I love all the doggies. All the doggies. Tiny teeth, giant hearts, muddy paws on my chest. I love all the doggies. Let them roll, let them jump, let them chew on my